台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大
各位贵宾早安。 两公约第3次国家报告国际审查会议。
Ladies and gentlemen, the 4 cluster with government representatives will start momentarily. Please put your cell phones to vibration mode or on silence. Thank you very much.
两公约第3次国家报告国际审查会议，公正。
Ladies and gentlemen, good morning. This is Cluster 4, review of Articles 12 to 17 and concluding observations 68 to 72. Before you speak, please raise your hand. Let us know where your city is. Let us know your affiliation and your name. While you speak, please speak at a reasonable pace for interpretation. Chairman, please, you have the floor.
Thank you very much, and good morning to everybody. I hope you had a good evening and night, so that we are all fresh for Articles 12 to 17 that we are dealing now in the morning, and as we did in the last 2 clusters. That afterwards we have the meeting with the non-governmental organizations, and please, for NGO representatives, really look into what our discussion is in the morning, and then try to tell us afterwards whether you have a different opinion, so that we, rather than delivering written statements to us in orally. So Articles 12 and 13 are 2 articles that refer to freedom of movement, freedom of residence, but also rights of aliens not to be deported arbitrarily. And I will start with those 2 rights, and then I pass on to Per Lorentzen for administration of justice issues, that is Articles 14 and 15. And we might have 1 or 2 questions on Article 16 by Bill Shevers. And also then Article 17, again a very important right to privacy, family communication, data protection, etc., where ROC will take the lead. So let me start with the third report, and I am on page 59 of the third report, which deals with freedom of domestic relocation. But there is also a right of every citizen to enter his or her own country without any kind of restrictions. And in the report, the government writes that citizens are required to register their relocation, so that they have to have a household registration. But those citizens without household registration in Taiwan, they are required to apply for approval from the National Immigration Agency of the Ministry of the Interior when entering the country. And when a citizen without household registration applies, she may stay for 3 months, etc. So there are quite serious restrictions for citizens to enter and stay that are a bit similar to foreigners, simply on the basis of the fact that they have no household registration. So I could imagine about homeless people, or but in any case, it is about citizens. So I would be grateful for any kind of explanation why in the right to enter your own country you make this distinction between citizens with and those without a household registration. That would be my first question.
Good morning to all the 5 committee members. MOI, anyone to respond? Please raise your hand first so that we can see where you are. Thank you for your question. I'm from Immigration Office, MOI. As for citizens' re-entry, according to current law, yes, they have to apply, yes, but we do understand that citizens have the right to re-enter, and Immigration Act is now being amended. And for any citizens in Taiwan, would you please slow down because we will provide simultaneous interpretation. Okay. According to current Immigration Act, right, citizens without household have to make registration, but currently Immigration Act is being amended. So for people without household registration, they can re-enter without registration, just like anyone else with registration. So the law is being amended right now.
Perhaps explain the rationale behind. Why is there at all an immigration procedure for citizens? Just because they have no household registration. So, if it's now being amended, can you provide us with more information when the new act or the new amendment will enter into force, and will that then mean that there is full equality among all the citizens to enter their own country?
Thank you for your question. The executive branch has already finished their review of the amendment. Currently, it is going to be sent to the Legislative Yuan. after the procedure is finished at the Legislative Yuan, the amendment will become effective. So that's the current status of the amendment. In the future, for citizens without household registration, as long as they have our national passports, they can re-enter the country or leave the country without any restrictions.
My second question relates to page 61 of the report, and there is a table 12, cases of prohibited exits involving citizens. So what are rights or what are reasons why citizens might be prevented from leaving Taiwan, like if there's a pending criminal case or probation and taxation issues. But then there are also a considerable number of people who are prevented from leaving the country for, and it's called administrative enforcement. Could you explain just by means of examples, what would be an administrative decision which is preventing Taiwanese citizens to leave the island?
MOI? Thank you for your question. As for forbidding citizens from leaving the country, maybe this is because they are going to their imprisonment is going to be executed. This is in order to finish the criminal procedures. Also for some wanted criminals, so judicial agencies forbid them to leave the country, or some administrative enforcement measures which are to be completed yet. According to the Immigration Act, this group of people cannot leave the country either, but currently we don't have any examples. Okay, MOJ, would you like to supplement some information on administrative enforcement? MOI mentioned that some people are involved in criminal cases. Do you have anything to add? Maybe the department from the prosecutorial offices? Anyone? Hi, I am an administrative enforcer from MOJ. Thank you for your question. I would like to explain on administrative enforcement. Under MOJ, there is an administrative enforcement agency. So there are some enforcement cases when people have to pay a tax or fine or other fees which are regulated by public law. And according to the law of administrative enforcement, if the cases are sent for execution, and if people have reasons not to pay or have the flight risk or hide their asset, then enforcement administration may limit the exit of such people so that they fulfill their obligations under public law to pay up. So when such elements in Administrative Enforcement Act are fulfilled, they may be forbid to leave. But of course, this principle upholds proportionality. And if they have already paid or if they have provide collateral, or if they do not have reasons to leave, or when the enforcement has ended, then such ban has to be lifted. Anything from Judicial Yuan on ongoing cases that limit the exit of people?
I speak on behalf of the Judicial Yuan. In terms of cases of prohibited exits, in 2019, we have amended relevant laws to be in compliance with the covenants, including prohibitions of exit by the court order. In other words, there must be court approval or judge's order before such prohibition can be imposed. In addition, there is a time limit that is in terms of regular monitoring and the procedural justice. They have been covered in our 2019 amendment.
I'm sorry that I have to repeat my question. I think whatever you said about criminal cases, this should be covered in the column criminal case restriction. And of course, that is where the courts are involved. The same is with probation. What you explained is paying taxes or fees. I guess that these will be under financial and taxation control. There are numbers. Then there are also military service control. But then there's another column that is simply called administrative enforcement. So I don't think this is a judicial enforcement. Administrative, in my reading, means an administrative agency can simply also enforce. That means prevent a person, a citizen, from leaving the country. And I just wanted to have one example. All the examples that you gave me, they fall under other. And I fully understand, of course, if somebody is in pretrial detention, he can't leave the country. Or if somebody is under investigation and not in pretrial detention, he might still be prevented from leaving the country in order to be available for the that's in every country of the world. And the same is if somebody hasn't paid taxes for quite some time and owes to the government fees for whatever, and refuses to pay, you might also prevent this person from leaving the country. But these are all covered here. My only question is, what does administrative enforcement mean? And these were 680 cases, for instance, in 2019, so it's not just a few cases. So I just wanted to have an example to better understand. I'm not saying it's a violation. I simply want an explanation.
So do we provide the number 680? Well, so maybe this number refers to the situation when people, from citizens, were prohibited from exiting the country under the martial law days. Maybe the NIA colleague can respond. Thank you. I speak on behalf of the MIA. In terms of the Immigration Act, we work side by side with relevant agencies. We do not take the initiative to prohibit citizens from exiting the country. We receive requests from different agencies. The Ministry of Justice, I speak on behalf of MOJ. In terms of the administrative enforcement, when it comes to monetary payment per public law, the executive branch's enforcement agencies are tasked to enforce such decisions. After tax is determined, then the tax authority will try to collect the tax payment. If, after such collection efforts, the tax is not paid up, then the administrative enforcement agencies will take over if the party concerned does not have sufficient property to pay up the tax, or if the concerned party intentionally conceals his property, then according to the law for administrative enforcement, he can be prohibited from leaving the country. For example, one person owes 20 million NT in tax payments, then the tax authority issues the tax statement to the person, but he does not pay, then the tax authority can transfer the case to the administrative enforcement agency. There will be an investigator to find out whether or not the person has property to pay the tax. If the answer is affirmative, then this person may be prohibited from leaving the country if he has not paid up.
But I guess that these cases are covered under financial and taxation control. But fine, I recognize that it's difficult to answer this question. It's not such an important issue. Yeah, in the responses to our concluding observations of 2017, point 55 on page 85, the review committee recommended the speedy adoption of a refugee act, which should also include the principle of non-refoulement. And your government responded that the draft of the refugee act was submitted by the executive to the legislative yuan for review in February 2016, so more than 6 years ago. And it then says the executive yuan will continue to work with the legislative yuan on legislative procedures. Since we have not only later received any further information, can you please provide us with an up-to-date information? Am I right that the Refugee Act has not yet been adopted? What are the reasons? And I do understand that in the Immigration Act you have a provision of non-refoulement, or in the law of extradition, the principle of non-refoulement against torture was adopted. But in then paragraph 170, you say prior to the enactment of the Refugee Act, the principles of the draft Refugee Act is kind of taken or are taken into account when somebody asks for asylum. And then you say assistance is provided through the Ministry of Foreign Affairs and the United Nations High Commissioner for Refugees for queries on the determination of the refugee status. So that's quite interesting. I mean, to what extent is this UN agency really involved in the refugee determination question. Can you simply explain a little bit more? I mean, if somebody is arriving in Taiwan, I understand that to ask for asylum is not really a reason to enter the country or to get a visa. But then you say there is a draft Refugee Act and UNHCR is involved. Can you explain the current practice on how the government of Taiwan deals with refugees, or to be more precise, with asylum seekers in the country?
The MOI? Good morning. I speak on behalf of the NIA. As for the progress on the draft of the Refugee Act, we are reviewing the draft so as to determine the better timetable for its passage. In fact, since after the reviewing of the Session 7 and 8 at the Legislative Yuan, the draft was not passed. So it seems that more consensus needs to be forged. And in the future, we will try to seek public opinion before we present a draft to the Legislative Yuan. And of course, we would honor the non-refoulement principle. If there is a refugee or asylum seeker, then we will deal with it on a case-by-case basis, considering domestic and international laws, providing assistance to such asylum seekers. So far, we have never sent back such asylum seekers to a country where he or she might be tortured. Therefore, our principle of handling such cases, there are three principles. First, we will not send them back. We will consider the applicant's best interest, and we will accept the oversight by our parliament. We will act in accordance with law.
Thank you very much. Could you also answer the other questions? What's the role of UNHCR in this country? I understood also UNHCR is involved if you cannot send back an asylum seeker to his or her country of origin, but then you might try to send this person to a third country. But does UNHCR have an office in Taiwan? Or how do you actually get the assistance of the UN High Commissioner for Refugees? Simply in very practical terms, because for a non-member state of the United Nations, it's quite interesting if a UN agency is actively assisting you, as is written in paragraph 170 of the responses to our concluding observations.
So the MIA, please. When we handle such cases, we work closely with the Ministry of Foreign Affairs. Moreover, we work with local NGOs. We will find whatever ways possible to seek help. As for UNHCR, maybe we can get help through the means I just described. In fact, there's no UNHCR office in Taiwan, no. However, how do you coordinate with the agency? Basically, we will work through the Ministry of Foreign Affairs. Maybe colleagues from the MOFA can say something? So I speak on behalf of the MOFA on asylum seekers.
On how we work with UNHCR. Well, there was a case, and in one of the cases, we wanted to contact UNHCR, but as you know, UN has no contact with us. Even though we try to reach out, UN refused to provide any assistance. So based on my understanding, if there are cases of refugees who want to come to help, well, as the immigration agency said, we uphold the non-refoulement principle. We also ask them for their willingness and to ask other third countries to see which countries are willing to receive the refugees. But indeed, UNHCR hasn't been providing any practical help to us.
Is that the correct now interpretation, because it's different than what is in the written report? So you might have asked UNHCR, but you have not been granted any kind of cooperation or assistance in, as it is written here, for queries on the determination of refugee status. So there's no active cooperation. Can I take this as the current affairs? Then on page 87 of the response to our concluding observations, you are also referring to political asylum applications by people from the People's Republic of China. And there you say there's a draft Refugee Act and an amendment to Article 17 of the Act governing the relations between the people of the Taiwan area and the mainland area, which allows people from China, even if they entered Taiwan in an unauthorized manner, to be eligible for existing regulations on special long-term residency based on political concerns. And then it says again, the preliminary review of the draft amendment was completed by the Legislative Yuan on 27 June 2016. It awaits the completion of further procedures in the Legislative Yuan. Again, this is almost 6 years ago. Has there been any progress since then? Has this been adopted? What's the current situation?
Ministry of Foreign Affairs.
外交部庇护法是你们的吧？
都两岸条例
啊，不是庇护法的。
Immigration Agency. This is Mainland Affairs Council.
好，我是陆委会代表李佩如。
Hi, I'm from Mainland Affairs Council. So you ask about the amendment. and political considerations for people from PRC. These amendments on Article 17 hasn't been passed by Legislative Yuan. Well, we will collaborate with the amendment of the Refugee Act and work with the Immigration Agency and to review all the cases. Immigration Agency, any progress on Asylum Act? This is Immigration Office. Currently, there hasn't been enough consensus on Refugee Act. So when it comes to political asylum, our approach was as, like I said earlier, for individual cases, if there were any applications or petitions for refugee asylum, we work case by case. We consider domestic laws and international practices. And then in our country, we try to provide appropriate assistance to people who are involved.
Thank you. Anything more on this, or simply both in the Refugee Act and in relation to mainland China, there has been no kind of developments in the last 6 years? Is that the conclusion that I can draw from? All right, then I'm almost done. I'm now going back to the third report on page 65. And now I'm coming to it's Article 13 now, and also expulsions of foreigners. At the end of paragraph 141, you provide the numbers of foreigners expelled, and there's a quite significant rise from 9,300 in 2015 to 16,500 in 2019. So more and more foreigners are actually expelled, and of course, if you expel foreigners, you also keep them in detention, and then you are distinguishing those who can leave. That is on page 66. Those who can leave in a relatively short time frame are placed in temporary detention centers operated by the agency's specialized operation brigades, with the others being placed in large detention centers of the agency. And again, between 2015 and 2019, and now you only refer to those in large detention centers, but there's also a significant increase from 8,500 to 13,500 in those 4 years. So my first question is, I mean, why is there such a significant increase? And the second question that was already raised in the in our list of issues, and if I go to the first list of the replies to the first list of issues, which is on page 42. We also asked about children. The reply says the reason for the increasing number of foreigners being expelled is also there are more foreigners visiting Taiwan. But then you say of these 16,000 detainees, and there are probably more also in the temporary migration detention centers, there were only 2 unaccompanied minors in 2018, 4 in 2019, whereas the toll with their families is 1 in 2020. So that's a very low number, and I'm happy about that. But I'm wondering, I mean, if people are staying without a visa, I guess there will also be families. So is it only adults that you are expelling and children then stay here? So if a whole family is coming with children and they overstay the visa or there are other reasons why they can be expelled, what's then happening to the children? Or why is this such a huge discrepancy between the numbers of foreigners expelled and detained in migration detention before expulsion, and only one altogether, one of these families had a child? So again, I would like to have an explanation in order to understand. If I read all these statistics together, there is a big question mark in my mind.
Immigration Agency. This is Immigration Agency from MOI. As for expelled foreigners and the numbers, well, by 2019, the number had been increasing. Here are the reasons. Taiwan has a need for caretakers and migrant workers. From 2017, there were about 350,000 migrant workers. By 2021, there were about 660,000 migrant workers. So that was an increase of about 300,000. Some of them overstayed, and the increase of the number of overstayers increased year by year. In the past 2 years, the number of expelled foreigners is controlled by some of our measures. By 2020 and 2021, the number of expelled foreigners were less than 10,000. I think in recent years, the number of expelled foreigners decreased. As for large shelters for foreigners, I think by 2019, there were about 13,000 foreigners. Again, this is because we have higher demand for migrant workers, and that's why, proportion-wise, there were more and more foreigners in Taiwan. And after 2019, because of the pandemic, well, in fact, we see a decrease of the number of detainees. From 2020 to 2021, the number is less than 10,000. As for minors and children, well, in large shelters under immigration office. Currently, we do not detain any minors or any children who are under 18 years old. Children, of course, have right to reunion with their family, and that's the factor we take into consideration. Thank you.
Green color. Is this correct? Okay. Good morning, and thank you for your participation. What we are now discussing is of interest to me because we have similar situations in Malaysia and in other parts of the world. Correct me. My understanding is that the individuals who are put into detention centers or who have overstayed are largely migrant workers. Is that correct? Yes? They are not families who are migrating from one country, but they're largely migrant workers because, yes, you're nodding. Because what I heard was that in Taiwan, there is a great demand for care workers in particular. And my question to you then is, in terms of the large numbers you're talking about who are put into detention centers because they have overstayed, is there a disaggregated data of male versus female? Because care workers largely in many parts of the world are women. And if they, so have you got information on this large numbers that you have on women versus men? Do you have that information? I'd like to get that information. When we give it back to you, you can answer. Secondly, when they overstay, and this is the experience in other parts of the world, it is because there are difficulties in their place of employment and they leave that employer. But immigration work permit, we are now looking at not just an immigration situation, we are looking at work permits of foreigners. And work permits of foreigners do not allow them to move from one employer to another employer. They have to reapply for their work permit to a new employer. And this is expensive. There are agency fees, there is levy from the government, and because the individual worker who wants to leave a particular employer is unable to do that, they just disappear and get work illegally. They work. And then if they are identified and caught by the police or immigration authorities, then there is an offense, and they're put into detention centers. So is that also a problem of work permit rules which are difficult to comply with? And that is why you have this increase in, so there is a labor issue as well. So the Labor Department also has to have a say on how to handle this problem. It's multifaceted. The problem is multifaceted. How are you addressing this? So it's not a simple question of they've overstayed, it's an immigration issue. So maybe you can tell us whether you have analyzed the entire situation. What is it like? And is there a possibility that you can relax your labor laws, your work permit laws, so that people can, the worker can stay on legally in the country? You make it difficult legally, they are going to go underground and become illegal. So perhaps you can give us some answers to that. Have you identified it as a labor issue also?
好，先请移民署先。
The MIA first, and then the Ministry of Labor, please. Thank you for the question. in terms of the proportion between men and women, yes, there are more female caregivers. But in terms of the industries, more male migrant workers are needed. Therefore, at large detention centers, mostly among foreigners who overstayed, most of them are migrant workers. And yes, there are more migrant workers in these large detention centers. You are right. As for the proportion between men and women, I don't have the data at hand. We will get back to you this afternoon with the relevant data. Now, please, the Ministry of Labor. First of all, thank you for the question. I will provide some explanations. For migrant workers who disappeared, based on our investigation, it's not because they cannot get work permits or they cannot change their employers. In fact, when they choose to disappear, there are a number of reasons. For example, maybe some of their family members working in Taiwan encourage them to leave their employers, or the migrant worker is not happy at the workplace. The migrant worker has difficulty adjusting to the environment, or there are better opportunities, higher pay out there, so the migrant workers choose to disappear. So it's very complicated. There are a number of reasons contributing to the disappearance. It's not directly linked to the difficulty in getting work permits. In addition, according to our Employment Service Act, migrant workers can change employers. In this regard, based on the past data, in fact, if there are 100 migrant workers who apply to change employers, 90 out of them will be able to do that. In addition, if the migrant worker in the workplace needs to change employers, or there is some dispute with the employer, the migrant worker can call a hotline dedicated to serving migrant workers, 1955, and the hotline will then refer the case to local government, and the local government will look into the situation, providing coordination or helping the employer and the migrant worker negotiate. So we do have some mechanisms to provide help in this area. Thank you.
So I'm glad to hear that there isn't much of a labor issue, because they can change employer, they can apply, or if there is a dispute, they can call a hotline and have a negotiated deal with the employer through the agency concerned. If it's a labor dispute of salary or wages that is not paid according to the contract, you can negotiate it. But are there situations where there is abuse of the worker by the employer, which is a criminal matter? And that is not easy to resolve, because foreign migrant workers I don't know about Taiwan. In other countries, they don't have access to legal aid or legal counsel that easily in the country where they are working. And therefore, they don't have, in other words, access to justice. And they then disappear or things like that. I'm not saying that is happening here, but I'm asking how do you handle it if it is not just a straightforward labor dispute, but it is a criminal situation where the worker has been abused, maybe physically even, by the employer. Do you have instances of that? And that is part of the problem for the worker, migrant worker.
那个以前劳动部。
劳动部。So I speak on behalf of the Ministry of Labor. Yes, we have noticed that migrant workers may be assaulted physically or sexually harassed, or sometimes even sexually assaulted. So the migrant worker can report to us. We will provide assistance, for example, in terms of litigation. We have the Legal Aid Foundation that can provide legal counsel to help the migrant worker. And we also have a budget to provide for that assistance. In the case of sexual harassment, sexual assault, or abuse, the Ministry of Health and Welfare also has a system that is the Domestic Violence Prevention Center, which can provide professional help, such as counseling. Moreover, in terms of the right to work, for such unfit employers, there are punishments. And within a specified period of time, the employer cannot recruit or hire migrant workers anymore. As for migrant workers, they have the right to change employers. And based on the level of abuse, the migrant worker is allowed to engage in lines of business their work permits does not allow. This is the kind of assistance we would render. How about the Ministry of Health and Welfare? So the Ministry of Health and Welfare speaking, according to our Sexual Assault Prevention Act, we have a reporting system. In case a migrant worker is sexually assaulted, they can report to the system. We can provide legal aid, mental counseling, psychological counseling, or if he or she wants to change employers or needs shelter, we will work with local labor department to provide assistance. Migrant workers, if they are implicated in criminal cases as victims, we do have victim protection system such as legal aid. And in the International Covenant on Migrant Worker Protection, we are also looking into the possibility of incorporating the convention into domestic law, and we also have other regulations in place to provide these migrant workers.
But we are really now in a totally different area. No? This is actually under the Covenant on Economic, Social, Cultural Rights. So if it's really about migrant workers' health so I would like to go back to Articles 12, 13, but if, please.
I think there are one more agencies, the middleman that hasn't been discussed on this in terms of migrant workers, because the agents are the one who really pay big roles and they benefit the more. Yeah, the workers agent, because these people coming from other country, they are not rich people. They came here because they don't have anything, because they need money. So the agents normally will take everything they have already. They had to sell their land, they had to sell their buffalo or pigs or whatever they have to come in order to come here. So the agent will be the one who provide the passport, the visa, and everything. I think, so we could actually say this is the modern form of slavery. And then that is relevant to the Article 8. Yeah, so I think these are the people, the middleman also has to be tackled. And I think the government of Thailand, or of Taiwan, in order to ensure the dignity of this migrant worker, can also use the article of the article number 8 on slavery to ensure that laws and policy in place to tackle this middleman. And I think because this middleman, the agents, they are the one who's been always know how to evade the laws and regulation in origin of in the country of origin and also in the receiving countries. So I think this is not just economic issue. Yeah, this is about slavery. This is about human trafficking. Thank you. I want to add more on that. Because when we just talk about the migrant workers and an employer are not the employer in real, not the one who really get the benefit. It is the agents, the middlemen, yeah, who have put all these migrant workers to the situation where they have no options as free persons or persons with liberty. Any migrant workers, they don't have liberty. So I think this has to be tackled from the other aspect of the covenant. So it is not just merely economic or cultural and social rights. Thank you.
Ministry of Labor. This is MOL. Thank you very much for raising your concern. On the issue of brokers, we have regulations to govern brokers' permits. And in the Employment Service Act, there are provisions that state what brokers cannot do. For example, they cannot overcharge, and they have to carry out their duties so that migrant workers will not suffer damage. So there are prohibitions in our law. As for a broker's fee, I think I can break it into two parts. First, that's the fee in Taiwan. So we have a fee regulation for brokers. Monthly fee is about $1,580 to $1,880. That's the monthly broker's fee paid by the migrant worker. But we stress that brokers have to provide services in order to receive such fees. If they do not provide any services, they shall not. As for fees, and another part of the broker's fees is for overseas brokers. In the country of origin, the jurisdiction then is the country of origin, like Vietnam, the Philippines, Thailand, and so on. In the past, we had organized many bilateral meetings with main countries of origin. We discuss the broker's fee in the country of origin and express our expectation that their broker's fee at the country of origin should be no more than the monthly salary of the migrant worker. But the final say is still in the hands of the governments of the country of origin. Additionally, we expect the brokers to follow the laws and regulations and provide quality services to the migrant workers. So we conduct annual evaluation of the brokers. Brokers are categorized as level A, level B, or level C. Level C means that they have poor quality. If for 2 consecutive years a broker receives C evaluation, then their business will be suspended. So we use the evaluation mechanism to ensure that the brokers are quality brokers. Furthermore, we perform active audits on the brokers to investigate whether they do provide good services to brokers. So we conduct routine visits and project-based visits to the brokers to make sure that the brokers do not break the laws. And in the end, if the migrant workers are not satisfied or have issues with broker's fee, migrant workers can call the 1955 hotline. Then again, procedures and assistance at the local government level will be provided. Brokers may therefore be punished, and the illicit fee brokers receive need to pay back or pay back the double amount of the fee that they receive. Thank you very much.
Just for a moment, I would like to go back to the to Article 13, deportation, because as I read before, you are distinguishing between temporary detention centers and large detention centers, and then you only provide numbers in relation to the large centers. What's the difference? So what does temporary detention center mean? Until which time or for how long can people be kept in temporary detention centers? And would you also have figures similar to the large ones? And the final question is that you said children are not detained in the large detention centers. So I assume that they are kept in the temporary detention centers. So would you have also figures on children who were detained or who are detained in temporary detention centers for how long before they are deported? Please.
Immigration. Thank you for your question. This is Immigration Agency. These special brigade temporary shelters and large-scale shelters are different in that at county and city level, police officers may transfer some migrant workers to the nearest shelters. So migrant workers will be sent to the temporary shelters first. And in 5 days, they will be transferred to large shelters. That's usually the duration of the transition. So temporary sheltering can only last for 15 days. Based on the current law, within 15 days, people have to be transferred from temporary shelters to large shelters because if continuous placement or sheltering is going to be conducted, then the courts have to decide for that. So temporary shelters are simply for the purpose of temporarily taking in the foreigners. Large shelters have bigger space. So those who are sheltered can have better space for themselves if they're transferred to large shelters. And that's an advantage of large shelters. As for minors who are under 18 years old, based on the data I have right now, there are no minors who are in the shelters. If you need extra information, we can provide them to you after the session. Thank you.
Just one, if you are in the large detention center, is there also a certain time limit?
To respond to your question regarding sheltering of foreigners, a temporary shelter is 15 days. Continuous sheltering is 14 days. Extended shelter may altogether be 100 days. So total sheltering duration is 100 days. After 100 days, without any conditions, the foreigners should be released from large shelters.
Are there any other questions from my colleagues on Articles 12 and 13? If not, then I would like to pass on to Article 14, please. And if it takes longer, we can also then take the break in between, but please start. Yes.
Is it working?
Yes.
Can you hear me? Okay, thank you very much. So, good morning.
Please use the microphone.
Morning, all of you. We will have now to embark on Article 14 concerning the procedural rights in court proceedings. And I have a number of issues I would like to raise. The first of them concerns impartiality of judges, or recusal of judges who should not participate in a case. And we know that the legal framework under Taiwanese law is Article 17, paragraph 8 of the Code of Criminal Procedure, which stipulates that the judge should not take part in a case if he had participated in the decision at a previous trial. We also know that there is a case law established by the Supreme Court where this rule has to some extent been limited, I would call it. So the mere fact that he had participated in the proceedings of investigation or interrogation at the previous trials does not imply that the judge should be recused if he did not make any decision. And there I would say this is quite a general rule, and one could even ask whether it is in fact not too general. I wouldn't say that the mere fact that a judge has participated in the investigation is in itself enough that he is barred from taking place in the deciding the case later on. But on the other hand, I would say I could imagine very well that there are cases where the circumstances are that there might be a question of impartiality. The judge may have taken part to a considerable extent, for instance, in the investigation. And also may he, so to say, have, during the investigation, made expressions which could be understood in the sense that he had already formed an idea of how the case should be decided. And therefore, the question for me comes up whether this case law, that only when he made a decision, is too limited. I recall, I think we all have heard of the old well-known maxim that's saying justice must not only be done, justice must also be seen to be done. It's a question of confidentiality of the public in the way the legal system is functioning. So my question would be whether the present situation under Taiwanese law, where impartiality, recusal only comes up as issues where the judge has made a decision, is too narrow.
Judicial Yuan, please. So I speak on behalf of the Judicial Yuan. You talk about how to ensure impartiality of judges. So as you explained, in terms of the Code for Criminal Procedures, Article 17, paragraph 18, there are some provisions as to the circumstances under which the judges should be recused. In fact, there are other regulations that are relevant, but I'll focus on CCP. So Article 17, paragraph 8, if the judge took part in the previous trial's investigation, the judge should be recused. If the judge fails to do that, the parties concerned can file for the recusal of the judge. So what does that mean to be involved in the investigation of the prior trial? So the Judicial Yuan's great justices have interpreted what it means to have prior trials. That is Judicial Yuan interpretation number 178. In addition, if the judge takes part in the previous trial and their extent of participation may be the basis to determine whether they should be recused, I agree their degree of participation should be considered. Also, in the previous trial, did the judge make some decisions specifically, or if the judge only takes part in the investigation in the previous trial, or the judge is involved in some proceedings in the previous trial, but then he's transferred to other cases or trials, then the impartiality of the judge may be considered in a different light. But in terms of the involvement in the previous trial, if substantive decision is made by the judge, for example, the judge is involved in making the decision of mandatory disposition, since the judge has expressed his opinions in that decision, then he has to be recused from the trial now. So according to our legal system, we have in the Code of Criminal Procedures provided for circumstances under which the judge needs to be recused. And there are some examples. Supreme Court this year made a decision which cited that the ICCPR, Article 14, Paragraph 1, anyone under criminal investigation and trial is entitled to fair and open trial. In addition, last year, there's another court decision which where the defendant set fire in a district court. And the president of the court and the judging and the presiding judge happened to be wife and husband. So in that case, the judge should be recused, since the husband-wife relationship would give rise to suspicion that there may be conflict of interest. Therefore, different levels of courts will exercise their judgment as to the impartiality of judges presiding over different cases. In the process, for each case, I would say this situation has to be determined on a case-by-case basis. There's no general rule to say in what situation the judge has to be recused. So there are decisions, cases in the past to serve as reference.
Well, I understand it correct that you agree that, so to say, that it is not in all circumstances decisive whether a decision has been made. There may be other circumstances where the involvement of the judge has been so intense that it could cause a question of impartiality if he continues to take part in the case.
In fact, in some existing cases, some courts have expressed similar views as you described.
I would like to turn to another question concerning procedure.
Please use the microphone.
Which is, of course, very important. It's the right to have a cross-examination. And the legal framework for cross-examination, I think, is, if I understand it correctly, is the Article 167 in the Criminal Code of Procedure, where it is said that the presiding judge shall not restrict or prohibit the examination of witness or expert witnesses unless the examination is, as it is said, inappropriate. And inappropriate, I think, is not a very precise wording, which will leave open for a lot of discretion for the judge. And the question, of course, could come up whether it would be desirable that to introduce some more precise regulation. I don't in any way intend that it could be regulated in all details, of course not. But and again, inappropriate is a very open and unclear wording. And it is alleged that there have been abuses in this respect. Whether that is true or not, I'm not going into. My question concerns and intervention concerns only the fact whether, so to say, the wording of the legal framework ought to be better. In this respect, also, I would like to refer to, it has been mentioned that there are situations where cross-examination under the Taiwanese law has been refused or is not possible. It concerns, for example, statements made by judges or prosecutors under the Code of Criminal Procedures, Article 159. It concerns an issue like sobriety tests by the police, appraisal reports, and so on, where it is alleged that this is statements like that are always accepted without any possibility to farming a cross-examination. If I would like, so to say, to ask whether this is correct according to the government, and if so, whether there might be a need to have a regulation of how far the cross-examination right could be used.
Thank you, Chair. Thank you, Mr. Reviewer. So I will provide explanation on the witnesses' investigation. Yes, cross-examination will be the main means to investigate witnesses' statements. We have a modified system here. The cross-examination will take place first between the legal counsel of the defendant and the prosecutor. And they can take turns asking questions to the witness so that they can discover the truth in the process. According to our Code of Criminal Procedure, only under some exceptional situations can such right be limited. So it does not mean that the judge can allow cross-examination to happen when the judges thinks it's appropriate. Only under exceptional situations can the judge restrict or limit the right to cross-examination. So according to our Code of Criminal Procedures, there's no obstruction to the right, to the exercise of the right to cross-examination. Secondly, the cross-examination system was first introduced to Taiwan in 2003. Since then, we have accumulated a lot of practical experience. In particular, we have open court for criminal cases. So anyone who would like to come and listen to the proceedings can join. So the cross-examination system was first introduced to Taiwan in 2003. But I believe the cross-examination has already been a very important way to gather evidence.
Next, you ask about evidence. Some evidence is given by people who are other than the defendant. And since such testimonies didn't happen in the court but are used as evidence, then the use of this kind of evidence is limited. The admissibility of this kind of evidence is limited. I think this is a universal principle because we want to conduct the trials in the court so that the defendant has a right to examination and confrontation. And if such testimonies are retrieved outside the trial, then unless the defendant agrees, then such testimonies are not admissible as evidence. But there are different levels of issues. At this level, defendants can ask the court to summon this witness and to conduct cross-examination with the witness. So admissibility rule and the fact that the defendant can ask the judge to subpoena the witness to the court for confrontation, I think these are two levels of issues. And also some evaluation reports seems to be able to use as direct evidence in the court. And the person who make that report, well, should this person be subjected to cross-examination? Well, in criminal code procedure, CCP in Taiwan, if the evaluation report, if these reports had already been reviewed and validated by the judge or by some specialized organizations, then such appraisal can be admitted. But of course, the judge can decide whether the appraisers will be summoned or subpoenaed to the court to give testimony on the appraisal. And if the appraisal is submitted in written form, then the prosecutors and the defense can all ask to subpoena this expert to show up in the trial to give testimony. Well, there had been discussions on how appraisal should be admitted as evidence. And the Executive Yuan had already made a draft and sent the draft to Legislative Yuan on appraisal and appraiser. So the principle will hold for the appraiser to appear in court to give testimony on the appraisal. There are various issues on this draft, and therefore we're waiting for more discussions at the Legislative Yuan. Thank you.
Thank you very much. May I turn to another question, which in fact is an old one in the sense that it has come up under the former review.
Per, if it is a longer question, shall we not then have a break, because it's now 1.5 hours?
I think I can take this one shortly.
Okay.
We'll take so on. It concerns the issue which was raised already in the proceedings, in review proceedings in 2013, where the situation is that accused has been acquitted in the first instance and then convicted in the second instance, and where we have argued that there should be a possibility for appeal in the third instance. The government has listened to that, and such a right has been introduced, which of course we are satisfied with. However, it is said that this right to appeal is not applicable to cases before November 17th, 2017. Not applicable before November 17th, 2017. It's not quite clear to me what that means, and I would like to have a clarification. It can, of course, mean that maybe the understanding that cases who are closed before 17th November 2006 are not covered. But my question is, it could also be understood in the sense that cases who started before 17th November but are still pending afterwards are not covered. Could you clarify in what way it should be understood?
I will ask Judge Zhang to respond to this question. Good morning. I am a judge from the Judicial Yuan, from the Criminal Division. Allow me to respond to your question. In July 2017, there was a judicial interpretation of 752. That interpretation discussed whether a guilty verdict at the second instance can be appealed, and whether or not the current CCP or the CCP at the time violated ICCPR. So it explains that if it's acquittal at first instance and guilty at the second instance, in order to comply with ICCPR, the defendant should have the right to appeal. This interpretation explains what cases what the new rule can be applied to, what new cases can apply this rule. So it states that on the date of the interpretation, if the deadline for the appeal has not arrived, because in CCP we have a deadline for appeal. It's now 20 days within the verdict. So within these 20 days, an appeal can be raised. So after this interpretation was promulgated, if there were pending cases at that time, which means that they were still within or within the time frame where defendants can apply for appeal, then they can do so. So in July 2017, the judges had to allow for such appeal in their courts. And the CCP amendments in November 2017, in fact, it did not change the content of the interpretation I just mentioned. Thank you.
Yeah, I think we have earned a break after more than 1.5 hours. Thank you so much for all the detailed answers. And I would like to propose, it's now 10:08, that we reconvene again at 10:30. It's a little bit more than 20 minutes, if that's fine with you. Then we have almost an hour left. Thank you.
现在是中场休息。
This is now the break. The review will resume at 10:30.
人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权 是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾 是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。 9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权 是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年。
About to begin, please raise your hand before you speak up so that the chair and reviewers can see where you are seated. Also, please make sure you identify yourself, your name, your affiliation, and please speak at a reasonable speed so as to facilitate the interpretation. Thank you.
Can we start? Yeah. Thank you for being back, and we're continuing with Article 14, and I give the floor to Judge Lorenzen.
Yeah, it works? Yeah. Thank you very much. I would like to address the question of compensation for wrong conviction. We have been informed that there is a draft law from 2019 which has not yet been adopted. And the draft project contained some rules in Article 7, I think it was, which has been criticized for going too far into examining again the guilt of the person, raises issue of double jeopardy and questions of the principle of presumption of innocence. And that Article 7 has then been replaced by a new Article 8. But the allegations still remain that the question of the contribution of the victim guilt will be examined in this respect. What is the reaction of the government to this critique?
Okay, here. 主席。好
Chair, thank you for the question. the criminal department from the Judicial Yuan. In response to your question about the draft of the Criminal Compensation Act, in the list of issues, there was a question about why we withdrew the draft. No, we did not withdraw the draft. This draft is still under review at the Legislative Yuan. As for the content of the draft, Article 7 of the original Criminal Compensation Act, we propose to delete Article 7 in the draft amendment. Then why did we increase Article 8, paragraph 3 instead? In fact, this is not a new provision. Rather, through the draft amendment, we try to move the second half of the Article 8, paragraph 3 to the first half. Why do we still retain this paragraph? If the defendant once ran away, or the defendant once did something to jeopardize the legal proceedings, then in determining the amount of compensation, this can be taken into account. Shall I continue? In this regard, the grand justices in interpretation number 670 mentioned that people's right to liberty, if it's sacrificed excessively, then in accordance with law, compensation should be provided. However, we should not abuse the system to provide compensation. So if the defendant is culpable in the situation, then the compensation, the amount of compensation may be decreased. However, the great justices also remind us that such situation only applies in it must be in accordance with the proportionality principle. So it seems that the great justices also approved that there should be specific provisions and the requirements as to the determination of the amount of compensation. And in the situation where the defendant is also culpable, then the amount may be reduced. That is why in the draft amendment, the Article 8, paragraph 3 is not a new addition, and there's also legal basis for its inclusion in the draft amendment. Thank you.
For this explanation. I would then like to turn to another issue which I think is of crucial importance. It concerns the DNA, the use of the DNA technology. And in particular, the question of keeping and storing of DNA samples. As far as I understand, there is a legislation which concerns the procedures for requests for DNA analysis and identification, the so-called Post-Convention DNA Testing Act. And there are rules here saying that the samples of evidence should be kept for 10 years, but when it concerns files of death penalty and life sentence, they should be kept permanently. We have been informed that the Control Yuan in 2020 made a study called on custody of stolen goods, evidence, and files in criminal cases, where they criticized a number of deficiencies in the safekeeping of such evidence. And also have we been informed, so to say, that there are various different rules on where and how it should be stored. It could be in the prosecutor's office, it could be by the police authorities. But apart from this Post-Conviction DNA Testing Act, all the regulations, as far as I understood it, are of an administrative character. And the question, of course, is whether there might be a need for having a real legal framework for storing these important pieces of evidence instead of just relying or mainly relying on administrative rules. Also concerning the way they are stored, it has been alleged that some of the samples disappear or are not stored under conditions which are adequate. And I would have to like to have the reaction of the government to these critics.
好，先请检察师，再请司法。
So first of all, the Department of Prosecutorial Affairs, and then the Judicial Yuan. Please respond. Good morning. I speak on behalf of the Department of Prosecutorial Affairs of the MOJ. On the storage of evidence in relation to death penalty and life imprisonment sentence. According to our rules, such evidence must be kept permanently. And the MOJ actually issued a letter to all prosecutors, officers, and investigation bureau that such evidence must be kept permanently. So there's an official document. The Code of Criminal Procedures also has provisions about the storage of such evidence. That is in Article in the Code of Criminal Procedures, Article 140, the Executive Yuan has organized meetings to look into whether there should be a specific provision to delegate the Judicial Yuan and the Executive Yuan to come up with an administrative rule as to how such files and evidence should be kept, including files in relation to death penalty. In the ministry, we are also discussing how we can better keep files of death penalty and life imprisonment sentences. We are continuously looking into this. As for the police storage of such evidence and files, maybe the colleagues from the National Police Administration can respond. I speak for the NPA under the Ministry of the Interior. After a conviction is made, if the defendant is found guilty, how do we keep the files? According to the DNA identification Evidence Storage Act passed in 2016, and per request from the MOJ in 2017, we already informed all DNA identification units that such evidence must be kept for 10 years. And relevant files and evidence have been sent to the prosecutor's office. So for the files and archives as well as samples, we are keeping them according to relevant laws. As for the storage of such evidence during the investigation stage, we follow the Code of Criminal Procedures as well as the investigative identification law. And after the investigation is done, we will transfer such evidence and files to the prosecutors.
Judicial Yuan. I'm from the Department of Prosecutorial Office at the Judicial Yuan. As for evidence or seizures and their safekeeping, just as my previous colleague, Prosecutor Lee, said, CCP has some stipulations how to safekeep the seized goods. On the safekeeping, on the returning of the seized object. And currently, in our legal framework, such stipulations are not centralized. So centralized system means that all of the related stipulations are under one law, but it's not our case. Our law is like that in Japan or Germany. There are different stipulations. So the prosecutorial offices or national police will follow the criminal code procedure to keep the evidence. And for seized goods, then the court has detailed regulations as to how the court will safekeep the evidence. And then upon conviction, the prosecutorial officers will decide whether to return or to terminate the evidence. So CCP has general stipulations, but at various departments, at prosecutor's office, courts, and police agency, they all have administrative measures and regulations on the safekeeping of evidence. And maybe the current issue is whether the current regulations are at such a low level, and therefore they should be upgraded. So we are talking to Judicial Yuan and various departments to see if there should be an new stipulation on authorization. There should be a stipulation that has a higher legal position that serves as an overarching regulation. Thank you.
Apart from the post-conviction DNA testing act, all rules, if I understand it correctly, concerning DNA samples and analysis and so on, rely on administrative regulation. My question does not go in, so to say, what the rules should be in substance, but more on the issue whether there might not be a need to have a real legislation, because the issue is, I think, without discussion, very important, to have a general legislation which regulates the rules on these samples. Has it been considered, and if not, why?
司法院能不能再说？
Judicial Yuan. Hi, I'm a judge from Judicial Yuan. Executive Yuan asked Judicial Yuan and other department to discuss whether we need to upgrade the level of evidence-related regulation and various agencies think that the evidence they keep depends on what kinds of evidence that is, because some agencies keep drugs and some keep explosives, so they keep different evidence, and different agencies will have different regulations depending on what kinds of evidence they tend to keep. For example, certain drugs are kept at the Investigation Bureau. So Investigation Bureau need to have more detailed regulations on the facility in order to keep a certain type of evidence. So is it really appropriate to add such a detailed stipulation in CCP, or do we need a higher level of piece of legislation? Well, we are still in the process of discussing. We don't have a consensus yet. So maybe CCP can authorize that Executive Yuan can give a legal order or ordinance which has a higher legal position than general regulations. As for whether evidence should be kept under specific conditions, well, every executive agencies can have their own detailed rules as to how to keep the evidence. So I think we are still discussing how to do it. Well, in CCP, yes, we have discussions on how to keep DNA and other evidence. For MOJ, now we create RFID for all the pieces of evidence. In National Police Agency, there's a DNA regulation. So in criminal cases, well, I think MOI can explain later. So this act authorizes different agencies to create their detailed regulations on the safekeeping of evidence. So MOI, would you like to say something to the DNA Sample Act? I'm from National Police Agency. On the issue of DNA sample archive, we have the DNA Sampling Act to follow. Under this act, it is clearly defined what kind of in what kinds of offenses what DNA has to be collected. There are also stipulations on the deletion of the evidence and the archival duration of such evidence. And this sampling is the samples from defendants and suspect. So this act stipulates how we keep the evidence we collect. Well, can we expand the application of this act to all the evidence? Well, evidence safekeeping still follows the stipulations under CCP. And according to the Post-Eviction DNA Act or regulation, we keep the DNA sample accordingly. So, well, there could be different forms of evidence. It could be a piece of clothes with DNA on it, with blood on it. It is also possible that the labs extract DNA from the blood. So the following DNA samples is what we call this kind of DNA samples. They need to be controlled at the specific temperature to be stored in special facility like a lab.
I have no further questions in that respect.
Thank you. That, I think, concludes our discussions on Articles 14, 15, unless other members want to raise issues. So we can move to Article 16. William Shevers.
Thank you. Article 16 is an often neglected provision of the covenant, perhaps because it overlaps with other parts of the covenant, in particular Article 24, dealing with nationality and registration of birth of children. Since the government has addressed some of these issues under Article 16, I propose just to discuss the issue of birth registration separate from nationality. I'll leave nationality for our discussion of Article 24, even though the two issues are not unconnected. The information that we've been provided seems to point to a problem in the birth registration of migrants who do not have a regular legal status here in the country, children born to migrants. And in the answers to questions, we're told that there is an obligation on the medical personnel who are involved in the delivery of children to report the birth. But of course, it seems to me reporting on the birth is not the same thing as the registration of the birth. We can report that a birth takes place, but it's separate from a child obtaining a birth certificate, which is a necessary document for a range of activities in the child's life. And while we can appreciate the obstacles that exist to persons, mothers who are not here, mothers and fathers, I guess, who are not here lawfully or in a regular legal status, their reluctance to report to the authorities in order to obtain birth registration, because this might then expose them to various measures. But there is a problem that has to be addressed, and somehow the situation of the children who are innocent, in a sense, some ways have to be found to address this. And I note that this problem is discussed to some extent in the independent opinion of the National Human Rights Commission, which was issued not long ago, paragraph 149 on page 64. And it's talking about it says the number of children born to foreign migrant workers that are not registered is significantly larger than the official estimates. And it says, and this is quite a strong allegation, it seems to me, that the executive yuan has also negligently delayed in the improvement and maintenance of these children's basic human rights. And so I would like to have a response to this charge by the National Human Rights Commission, and some better indication than what we have in the documents that have been prepared by the government to indicate how this problem, how this challenge is being addressed. Thank you.
内政部
MOI. I'm from Immigration Agency. For For non-Taiwanese children, as long as they are born in Taiwan, Ministry of Health and Welfare will make the birth reports. The reports will be sent to the household registration department. The information will be transferred to immigration agency, and then we will make visits following such information. If the birth mother stays in Taiwan legally, then we will help them to get the residence. But if the mom cannot be found, we will give the child a temporary residence permit according to the nationality of the mom. But if both the mother and the child cannot be found, well, if we find them, then we help get them the travel document so that they can return to their country of origin. That's the current practice. Thank you.
The NIA speaking. For migrant workers with children who cannot be contacted or found, in the interest of human rights protection, we do not put them in detention centers. Rather, we will consider other measures before they are sent back to their country of origin. If they have no economic means to find a place to stay, then the NIA will ask NGOs to help, because there are temporary shelters in different parts of Taiwan to provide accommodation for these migrant workers and their children. Thank you.
Is it correct to say that you reject the allegation of the National Human Rights Commission that Executive Yuan has been negligent?
The NIA. The National Immigration Agency speaking. For dependent children who do not have guardians with them, we will provide foreigner resident certificate so that they can have access to healthcare and education. So I think the question is the critique from the National Human Rights Commission. Maybe we need to go back to check if the NHRC's report includes such criticism. Have you read that NHRC's report or independent opinions? Can we ask the reviewer to provide us more information, or maybe the Ministry of Health and Welfare can first respond? Yes, the Ministry of Health and Welfare speaking. In terms of the Department of Social Affairs, we try to look after children born by migrant workers. As long as we receive reports, we will see to that. In fact, in terms of healthcare needs, vaccination, subsidies for healthcare expenses, we try our best to provide help. For some children, they might need placement. We can also arrange their stay with foster homes. As for the expenses, I would like to thank the Ministry of Labor for their budget dedicated to this purpose. So through the NIA, the MOI, we try to help children find their parents so that they can stay together as family. However, if their parents cannot be found anyway, then our last resort is to help the child be naturalized as a citizen of our country. So this is what we have been doing. Thank you.
Okay, anything else on Article 16? And perhaps I could suggest that the allegations of the National Human Rights Commission in paragraph 149 of their report would be studied more carefully, and then to see how to solve this kind of differences of data, and because they are speaking but a quite high number of 9,381 non-native newborn cases, including 496 non-native children born to foreign migrant workers who are unaccounted for. So perhaps that is an issue to be looked into. That brings us to Article 17, and I pass the floor to Roka.
Hello? Yeah, thank you. Thank you, Chair, and good morning to everybody. Thank you very much. I've read the response to the report, to the recommendations, and regarding the right to privacy. I think what we need to understand is the role of nations, the role of state, the role of the government is to provide protections and make sure all the measures, administrative measures, will make sure that the right to have privacy and free from attacks of privacy is guaranteed. And what I have seen on the reports here, on the response, is more on the administrative. How is, for example, the identifications, informations in the ID, information including the face recognitions. Face recognitions in the airport is also here categorized as voluntary. There is no such voluntary face recognitions in the airport. It is all obligations. Yeah, so I think that's, I wanted to also clarify on that. What I really want to see here, Chairman, and to all the relevant government agency here is, what is the, how do you really make sure that all this data is protected, that is no infringement, there is no other third party who have access to that data? And also, especially, we know what are the measures in place to protect all this privacy on data of citizens or data of foreigners who come here, especially during this difficult time, the pandemic. Because I've seen in other places, there are many objections to applications, because that kind of applications are accused of being collecting data that disrespect and against the fundamental rights, the human rights regarding privacy. I think that's the questions that I want to seek clarifications from our government of Taiwan. Thank you.
好，先请内政部再。
So the MOI and the National Development Council, please respond. Good morning. I speak for the Department of Household Affairs. Speaking of the digital ID card, in fact, when we planned to launch the digital ID, we thought we would launch it in 2021 on a pilot basis. Basically, we would like to store the information on the traditional ID card into a chip, and citizens can choose what personal information they would like to provide. So this ID, digital ID, actually was designed to protect their privacy. And the digital ID design also allows people to choose whether they would like to provide additional information, such as natural person ID. However, later, there's some public concern about the launch of the digital ID. That is why in January 2021, the Executive Yuan decided to halt the launch of the digital ID. We will not launch it until a dedicated law is enacted. The NIA and the National Police Agency, maybe you can explain the legal basis for facial recognition technology use. The NIA, in terms of the entry and exit of the country, you can start. We use facial recognition at airports, right? Yes. I don't have such data at hand. Can I go back and provide you the data later? So we will provide the relevant data on the use of facial recognition at airports later. How about the National Police Agency? Please, your review on the use of facial recognition. NPA, do you have legal basis for using facial identification technology? Okay, you can go back, do some homework, and then come back. How about the National Development Council? First of all, on the right to privacy, I would like to explain the protection we provide in Taiwan. Even though the right to privacy is not part of the Constitution, but according to the Grand Justice's interpretation, it's being recognized that the right to privacy is part of basic human rights. In addition, Taiwan has enacted a Personal Information Protection Act, which is applicable to the public sector and private sector in terms of the use of such personal data collected by the government. There has to be very specific explanation as to the use of such data. And of course, the proportionality principle must be followed. You don't collect the amount of data unless it's necessary. If there's any breach of such rules, there will be criminal penalties or fines imposed. As for the use of facial identification, indeed, facial identification is not invasive. It can be done distantly. So under the pandemic, it can be a very useful tool to control the movement of people. However, through facial identification, you can collect personal data for sure. So if we collect such data based on facial identification, then we have to follow the provisions of the Personal Information or Personal Data Protection Act. understanding the sensitive data collected through this way, the National Development Council is working on a guidelines in relation to the use of such data collected through facial recognition. We are going to organize public hearings during the second half of this year. Thank you.
Yeah, my question is, what is the protections, the policy of protections in hand? Because everything's like here, like protections. If you look at including the getting of regulations governing urine tests for substance abuse by specific military personnel, it is a procedure, but it says it is to protect privacy. So I don't see maybe I don't understand, but I don't see the connections. How does taking the urine is protecting privacy? Or how is the taking our pictures involuntarily protecting our privacy? The other thing is, so it's really the protections aspect that I wanted to seek, because that is the most important thing. I think it is, in my personal experience, it is useful to have personal information with our government, because in any time we seek for help, they know we are their citizens. But it has to be protected. My personal information belong to me. That's my personal sovereignty. Yeah, I'm speaking now as in the head of citizens. No one have the rights to use my personal identity for things or business that I don't give my consent. So these are the aspects that has to be protected. How does the government make sure that there will be no misuse of these informations collected through the mechanisms that we already have in the laws and regulations? And especially, this is involving many different agencies, many different ministers, departments. So that's why it's very important how is the protection aspect is there. And then, so that's kind of things that I wanted to see. It's not about how do we regulate, how do they do it, the guidelines, how do we conduct the facial recognitions, how do we, but it's really to the safety of these informations. And especially, is there any regulations on the privacy, how is this protected in the third parties? So it means not the state nor the person, but third parties such as bank, insurance, and etc. Because these are the actors that sometimes they use they really breach and intrude our privacy. So I think this should be also regulated if there is any policy on that. And again, how are these aspects, again, protections of privacy, guarantee of the rights to privacy is protected during this pandemic? And I think you want to elaborate on that, Chair?
Perhaps we can get first a response from the government.
Okay, National Development Council. when executive branches collect personal data, the Personal Information Act has clear stipulations saying that there must be a specific purpose for the collection. If such information is going to be used for other purpose, then this Information Act stipulates in Article 6 and Article 16 that if the information is going to be used for other purposes, then such use must meet the requirements stipulated in Article 6 of the Information Act, Personal Information Act. So we have a Personal Information Act, and the regulator is the National Development Council. So in Article 15 and 16, there are stipulations on collection, treatment, and use of the information. For example, the information is necessary within the scope of the census, does not hurt the benefit of the individuals, and so on. So these are all stipulated in Article 15. And in Article 16, it says that government agencies or non-government agencies, when they collect information, they have to inform the individuals. And in different pieces of legislation, there are protection clauses too. For example, in the DNA Sampling Act, there is a stipulation about protection of privacy. In Urine Collection Act, there's also the protection clause in that regulation. In the Bank Act, there are stipulations on protecting individuals' information. So there are various pieces of legislation, and in those pieces, there are clauses about the protection of individual personal information.
I think you just also mentioned that the right to privacy, which I consider as one of the most important human rights in a liberal democracy, is not part of the Taiwanese constitution. Why is that? Is there perhaps any kind of explanation why the right to privacy is not protected? And if this is the case, what kind of role does Article 17 of the Covenant on Civil and Political Rights then play in the judgments of the courts in Taiwan?
National Development Council. Thank you for giving me the opportunity to clarify. What I meant was that even though right to privacy has not been listed explicitly as a right to be protected, however, Judicial Yuan interpretations and the Grand Justice had explained many times. There are 4 or 5 JY interpretation, including number 603 interpretation. Grand Justice acknowledged that right to privacy is one of the privacy that is protected under the Constitution. So right to privacy is one of the fundamental rights that is protected under the Constitution, according to Judicial Yuan's interpretation.
Does Article 17 play? How can you explain cases where Article 17 has been directly applied in order to protect the right to privacy, and what we are now discussing in particular, personal data protection, and I'm talking in particular now in the time of the COVID-19 pandemic. I'm talking about big data.
卫福部先说明。
Ministry of Health and Welfare. So I want to clarify the question. So you want to ask, about geofencing? Well, I think it's the responsibility of the Disease Control Center. Well, do we have any colleagues from the disease control? Okay. This is disease control from Ministry of Health and Welfare. Some personal information is collected during the pandemic, and such information is used only for preventive measures and for pandemic investigation. It will not be used for other purposes. And it's kept for the maximum of 28 days, and then it will be destroyed, and it will no longer be kept. During the pandemic, we asked the opinions from human rights experts before. In the past 2 years, when we designed, for example, geofencing and other preventive measures, and the SMS contact tracing measure, which was just dropped last week, but all of this information is used solely for the purpose of preventive measures against the pandemic. And so say within certain days, 28 days, or after 28 days, the information has to be destroyed, and there should be a check and balance. For example, MOHW collected the data, and then after a while, it has to double check itself whether or not it has indeed deleted personal information after a certain date. Judicial Yuan, do you have anything to add? Do the courts use Article 17? Well, let me ask whether there are some judgments made by the courts, because I need to check with my colleagues whether there are any judgments that apply Article 17.
Yeah, thank you very much. When do you think, I mean, we have now the facial recognition issue, both at the airports, but also other ways how facial recognition is used. When do you think, and now also about the judgments relating to Article 17 of the Covenant, when do you think you could provide us this information? Shall we put it at the end of this afternoon session? Would that be time enough? Or because in principle we are concluding our interaction with the government this evening. Yes, I see nodding. Okay, so we just add it after the cluster 5, no? That means in the later afternoon today, I would be very grateful. Are there any other questions from my colleagues on Article 17, privacy, communication, family, bill, or others? All right, then thank you very much. We are at the end of our time. This was a very, very comprehensive discussion that we had on so many different issues this morning. I'm extremely grateful for all the responses that we have received from so many different government agencies. And we have a short break now, and we then have the interaction with the non-governmental organizations, and we see you again at 2 o'clock in the afternoon when we are continuing with Cluster 5. That means the remaining Articles 18 to 25. Thank you very much. Thank you indeed.
谢谢。本场次到此结束。本场次会。
This is the end of Cluster 4 with government representatives. Moving on, the review will be between the committee and NGOs. We will resume at 11:40. Thank you.
有使用需求者，请改至11楼使用，谢谢。
被评为亚洲唯一公民活动自由度开放的国家，我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。 台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3
with the non-governmental organizations, as we did also yesterday. So I hope that you could follow the discussion we have had with the government on Articles 12 until 17. So I would be happy to have again your feedback, but also your additional information. And I would like to again cluster it in different parts. So starting with Articles 12 and 13, freedom of movement, also including refugees, non-refoulement, this issue, and in particular also where this distinction between citizens with and without household registration is coming from, and whether that plays still a role in the country, that you have citizens that actually need an immigration permission in order to enter their own country. That is an issue where I feel that we were told that the act is being changed, but I'm not quite sure what the real situation is currently. I've seen you already. Please, Governance Watch. Please.
Yes. 在发言之前，先提醒一下各位。
And before you speak, Allow me to remind you that please identify your affiliation and your name. When you speak, please use a reasonable pace for interpretation. Thank you. 谢谢，我是人员盟黄松丽。针对第13条有意见要提出。
A lack of a regulation to protect foreigners who are already in Taiwan, because according to Immigration Act, there are some people who can be deported, and so there is a regulation. It's called Regulations Governing Forcible Deportation of Foreigners. And according to that according to that regulation, a review committee will be held prior to forcibly deporting a foreigner who has acquired a permit of residence or permanent residence. But what I'm going to say is that there is nowhere, either in that Immigration Act or this regulation on forcible deportation, which mentions about the principle of non-refoulement. So people can be deported, and it is to the discretion of that committee. But there is no guideline on how that committee should judge whether to forcibly deport a person or not. So we recommend that there should be such a guideline regulating the forcible deportation to at least protect people who can be deported to where they can be subject to torture, but also to protect the right of union of a family, because it is possible that one member of the family can be deported, and associated with that is for the children in that family to have the right to be heard, because under current regulations, the government requires that the children submit written opinions rather than having them to express in a suitable occasion. So that is my recommendation. Thank you.
Can I immediately follow up? Because we heard that the number of children who are deported and also kept in migration-related detention is extremely small. They said there are no children currently, according to your information, and I'm talking both about unaccompanied minors, but I'm also talking about children who are immigrating together with their parents, with their families. According to your information, is it true that children are more or less not taken in custody, but also not being deported?
No, actually it's two different things. One, in the morning, they talk about mostly about the children who were born by the migrant workers, and they do not at that time have any status. But what I talked about the Immigration Act and the deportation deals with a person who have already acquired the permit of residence. So there are two different issues.
Yeah, I was not talking now about children born in Taiwan. I'm talking about, I don't know, it can be immigrants, it can be asylum seekers, but foreigners, foreign families. And in many countries in the world, today refugee flows also include unaccompanied minors, 14, 15, 16-year-old children who are trying to flee or immigrate or enter other countries. And if they are not considered to be eligible, not considered to be refugees, etc., then usually they are deported to their countries of origin. From the information that we received, we were told that these are, also children are not included. There are more or less no children in immigration detention, and no children are deported.
Professor Nowak, can I respond for that?
Yes.
Yes, I'm
please.
Yiling from Amnesty International Taiwan. According to the Article 38 of the immigration law, the children under 12 years old are not allowed to be detained in our immigration detention center. So it's true.
But yeah. I'm talking children up to the age of 18.
Yeah, but the law is only talk about the 12 years old. So
yes. So are children between 12 and 18?
Then we need the statistics from the government. Yeah, but the article is specifically forbidden the children under 12 to be detained. Yeah.
I hope so. I hope so. But still, that doesn't answer my question. I mean, do you have any kind of indications? I mean, we are talking about many thousands of people who are in temporary migration detention, in large detention centers, in order to prepare them for deportation. We are talking about thousands of people who are deported. And according to the information by the government, there were 1 or 2 children included. If that is true, I'm very happy because we, according to international law and the Convention on the Rights of the Child, children should never be in migration detention. But still, I'm a little bit doubtful whether this information is actually correct. So that's why I'm asking you whether you can confirm the information by the government or not. Please.
So for those who are in the detention center, most of them would be migrant workers. Yeah. And if they give rise to children, then those children will be very small. So I don't think there will be people who are between 12 and 18. Yep. So if they are, so mostly are. If they are children, they are under 12, okay. And so they would not be there.
But what is happening if there are migrant workers with having a 5-year-old child? Do they separate children from their parents, or do they detain them with the parents?
Sorry,
Amnesty. Oh, yeah, please.
你要讲吗？
好，我是台湾人权。
I am Zhou Guanru from Taiwan Association for Human Rights. Based on the data we can find, in this case you describe, there is no sufficient legal protection. In other words, there's no consideration given to people who are minors that stay at such detention center. But it seems that if the female detainee is put into the detention house and has children under the age of 3, the child can be allowed to stay with the mother.
Now you're talking about prisons. I'm not talking about a prison. I'm talking about migration-related detention in order to prepare deportation.
I think it's because the translation, she's talking about immigration detention.
So if a mother or a father who has a child is deported, you are saying they keep their children up to the age of 3. That means if they are 4 or 5, they are separated?
Chair.
that would be even worse.
Chair, excuse me.
Please. I don't know, perhaps there was an interpretation mistake, but can you try again to clarify what you wanted to say?
Can I interrupt?
好，我们查到了
Okay, based on the data and the regulation we have found, there are 3 regulations. One is about national immigration regulation. Children under 12 must not be put to such immigration detention center. And for female persons put to such immigration detention centers, they are allowed to keep their children under the age of 3. And there's also the administrative rule, which says before deportation, foreign peoples in such immigration detention centers with children under the age of 18, they can stay. But that's all I can find for now.
Data on that because during the COVID-19, NGO is not allowed to do any visiting in the immigration detention center for any monitoring. So it's only rely on the statistics from the government.
Excuse me.
Please.
I want to give some context. In the case of migrant worker, it is very rare that a migrant worker will bring along the kids together. Unless they got pregnant here. Yeah, so that's the case. And also many of the rape cases, we never knew what happened to them, or some of them actually, when they were about to give birth, they were sent back. That's why there are many cases of child was born on the plane or in the airports. Because it's very rare. Even if they have kids, babies, they will leave their kids at home. Yeah, before going outside. So that's why it's very rare. And there is in Indonesia, there is a very clear regulations about the workers who go outside. They're not allowed to bring kids. No one will accept them if they have extra luggage with them. So I think that's the reason, the logic behind the number of kids underage is not in the detention, because there's no way they will bring their kids home here.
All right. If you have further information and you can provide it in writing, I would be very happy. The second is about, again, refugees. I mean, we had some discussions already before, but I'm still a little bit unclear. So, as we know, there is no Refugee Act so far, but there is the whatever Extradition Act or Expulsion Act that includes the principle of non-refoulement. But then the government said that in order to determine the refugee status, they used the draft Refugee Act. Then it's written also with the assistance of UNHCR, but it was later corrected. They said UNHCR does not, in fact, cooperate with Taiwan because it's an UN agency. So I'm still not really clear what happens if a person is coming from whatever country and is saying, I am applying for asylum in Taiwan. Is there any kind of refugee determination? Are they simply treated as any other immigrant? If they cannot be sent back because of the non-refoulement principle, what is then their status? Do they have any kind of residence permit? Do they have the right to work? Do they get basic services like housing or food or whatever? So is there, or is it a big loophole? Yeah, what's the actual situation of asylum seekers / refugees in Taiwan, please?
Eileen Chu from Amnesty International Taiwan. There is no refugee protection or review mechanism in Taiwan, and there's no non-reformal articles in our immigration law as well. So, if someone no.
But the government says yes, it is included in the.
No. It doesn't exist. It's only some special programs for some cases, like for the Hong Kongers. Then the government established a special office for them. But what is the procedure is not clear and not transparent. And there is no appeal procedure for the asylum seekers as well. And also what they get is not the refugee status as well. They are using other ways, like suggest them to apply for study visa or employment visa in Taiwan. So it's not a long-term residency visa here. So yeah, so I would like to say the government said they never reported any cases back to the place which may face torture or inhuman treatment, but actually the asylum seeker people, like the Tigray people or the Uganda LGBTI people or even the Turkish or the Ukraine or Hong Kongers, actually, or exiled Tibetans, actually they all have to use other ways, other visa to stay in Taiwan. And some of them already overstayed for more than 5 years. They are not allowed to work to get the medical service, and even not allowed to relocate or go to the third country or reunion with their family member, or even get vaccine or any kind of medical service related to COVID-19. So the government actually didn't provide any assistance for these cases. It's all provided by the NGOs, including the accommodation and even the medical fee, or maybe their some allowance for their life. Yeah, so that's the truth. So the government said they didn't report any people back to their home country, but actually they will report them back to the last destination before they enter Taiwan. So like when they transfer in Malaysia and enter Taiwan, then if they find they are illegal, like there is a case, is a Kurdish people from Syria, then they send it back to Malaysia. So they say it's not violate the non-reformal because they didn't send them back to Syria. But for us, it's not the. We still think it's they already violate the non-reformal principle. Yeah.
That's a kind of a chain refoulement. But if I may read from the response of the government to the concluding observations from 2017, it's paragraph 169, where they say the principle of non-refoulement against torture was adopted in the amendments, and Article 9 allows Taiwan to reject extradition requests of foreign entities if there are substantial grounds for believing that the extradited person has previously been or would be in danger of being subjected to torture or other cruel, inhuman, or degrading treatment or punishment. So are you saying that this is simply wrong? Please.
好，我今天是西藏台湾人权连线。
So I am a director from the Human Rights Network for Tibet and Taiwan. I'll give you one real example in response to your question. A few NGOs are now helping a Tibetan trying to win a litigation to pursue the right to live in Taiwan. Right now, the litigation is pending in the Supreme Court. So far, the court decided that they cannot stay in Taiwan. And these Tibetans actually were on exile. They first went to Nepal, and then they came to Taiwan. But the court here denied the fact that they have the right to seek asylum. Whether or not these Tibetans can be deported to Nepal, where they may face torture. But the court says that as long as these people are citizens of Nepal, they should be protected by the Nepalian government. They will not be prosecuted. But according to some international reports and studies, even research conducted by Tibetans themselves, Tibetans, whether or not with nationality in Nepal, face restrictions to their rights. Sometimes there be indirect prosecution by the Chinese government while they are in Nepal.
The court think that according to Article 16 of Immigration Act, as long as the elements are not satisfied, then they don't have to consider refoulement principle. And they also believe that as long as these dependents have Nepalese nationality, they will of course be admitted, and airlines will of course take them. So the government or the courts believe that they don't even have to consider whether there's a probability of violating.
Please don't read out, first of all, not that quick for our interpreters. And second, that was not my question. I certainly can accept that there are cases where the non-refoulement principle is violated in an individual case. My question was about the legal situation. The government says the principle of non-refoulement has been adopted and included, and I understood various representatives, both Amnesty International and others, saying that's not true. And I simply want to find out what the truth is. Because that is also then, of course, for us important in our concluding observations. So has the principle of non-refoulement been included, yes or no? And if you don't know, perhaps you can provide us later with this information.
Could I
yes, please.
Just advance a hypothesis on this? Perhaps when the government says that it's recognized, they're referring to provisions in the Extradition Act, which would be quite normal in an Extradition Act where the treaty would not apply if there was a threat of capital punishment or something along that lines. This is quite typical in extradition legislation, and perhaps the government is claiming that this is how the non-refoulement principle is recognized in the laws of Taiwan. So but I'm speculating. Yeah. I'm not an expert on the law of Taiwan, and I would hope that we might find someone knowledgeable in the audience.
So that might be only for extradition, but not for expulsion, no?
It's a thesis,
a
hypothesis.
Yeah. Okay, perhaps we can leave it open now, and if you could later find this information, I would be very, very grateful. I leave it here for Article 12 and 13. Is there anything else from your side that you would like to add that has not been dealt with in our discussion with the government? Please.
In the current Article 9 of the Immigration Act, there is no mentioning of the principle. So it's not there. It's perhaps in some draft.
Okay. Please. So Article 9 of the Immigration Act.
Yes.
No principle.
But it wouldn't be in the Immigration Act.
Yeah.
It would be in the Extradition Act.
Extradition or Expulsion Act.
Yeah, but that's what the government said. It said that it's in the Immigration Act.
Okay. Thank you, please.
Thank you, Mr. Chair. I would like to talk about Article 12. Yes. 我想针对上午政府
In the morning, the government talked about administrative enforcement and limits the freedom of movement. There are 3 points I want to mention. First of all, authorization. Executive branches have extreme discretion. They can make administrative enforcement. They can limit people from leaving the country because of tax issues. And in this process, remedies are ineffective. So point number 1, executive branch directly use their executive power to take away the rights of liberty and movement, and that is not in line with the 2 covenants. Second, and of course, the steps before the limit prohibiting people from leaving is that, well, there should be effective remedies, but I think other NGOs have mentioned that such remedies are ineffective. So the enforcement is not proportional, meaning in practice, many administrative enforcement measures are not correct. People are not able to pay up. However, they have to face the fact that they cannot exit the country. And in the administrative court, tax cases are the most cases, and people's winning rate is only 1%. So only 1% of people can win. One time, a homeless person's bank account was used by others. And after this homeless person died, his brothers and sisters are still forbidden to leave the country. Second, there are ranges for the tax that allow for such limitation or but according to Article 17 in the Administrative Enforcement Act, as long as the government feels that what you owe is more than $3,500, so if the government unilaterally believes that you owe the government $3,500, then the government can impose upon the people administrative enforcement and forbid people to leave. So here are the recommendations. We suggest that you may include this in your COR. First of all, and ask the Administrative Enforcement Agency and Ministry of Finance to change any regulations that limit people's right to leave. For example, Article 17 in administrative enforcement, which allows for repeated bans imposed on people from leaving the country. Second, and they should not technically escape from the spirits stipulated in ICCPR Article 12. They should be very specific in their clauses. This is Taiwan Association for Human Rights. I want to talk about non-refoulement. Without asylum channels, it is impossible to carry out non-refoulement because the government will not take the initiative to investigate whether these people are asylum seekers. And of course, they will not consider non-refoulement. in 2018, some Kurdish people were deported. This is in Amnesty International. I think Extradition Act hadn't been amended at all since 1980. So we haven't seen any provisions that that prevent the government from sending people back to where they may be subject to cruel treatment or death penalty. And I think in laws or in Immigration Act, Article 36, and regarding exportation cases, there isn't the mentioning of non-refoulement principle.
我要补充刚刚。
I want to add some information which was provided by Association of World Citizens. So it was earlier mentioned that if the government believe that there's hidden assets of the people, and then they can forbid people from leaving the country, but that power is too great. How do they find out that these people have so-called hidden asset? Because there were cases when we know that people do not have this money, but they are requested to pay a really high tax amount of tens of millions of NT dollars, and then they are forbid from going home. And only 1 or 2% of the tax that is paid account for the total tax debt. So I believe that those kind of cases infringe upon people's rights gravely.
Bill?
I'd just like to pursue the non-refoulement
Yes.
issue because I have a question that, again, perhaps we can find.
Please speak closer to your microphone. Thank you.
The answer in the room. The recognition, the explicit recognition of the non-refoulement principle in legislation doesn't seem to me to be the most important issue. After all, we don't have an explicit recognition of the non-refoulement principle in the International Covenant on Civil and Political Rights. But that hasn't prevented the Human Rights Committee from considering that this is a natural and logical corollary of the covenant. So really the question to me is whether judges might enforce the non-refoulement principle. And so the question is, has there not been any litigation? Because this isn't just a theoretical question about what's in the legislation, but have there been cases where somebody was being sent back to a country where they would be subject to torture or cruel, inhuman, or degrading treatment or punishment, where they applied to the courts to prevent the expulsion on that basis, and where it was either accepted or denied? Is there any judicial recognition or statement on the principle?
Thank you, please.
那我想补充一个桃园。
I want to talk about a judgment by Taoyuan's court. It was at the end of 2019 and at the beginning of 2020. There was a Kurdish person from Syria. Well, they use fake passports, wanting to go to Europe, but they transferred in Taiwan. But immigration agency caught them because they used false passports. The Kurdish people were sent to the prison on falsified document. So they served their sentence in prison, and then the court judged that, okay, you finish your sentence, but in Taiwan you don't have any families and you don't have reasons to come to Taiwan. You don't have legal visas. So in addition to deciding that they have used falsified documents, they are also subject to expulsion. So it's very clear that the court decided to expel them from the country.
The court decided to expel them, but did they challenge before the court their expulsion on the basis of the threats
Yes.
And did the court rule that that was not an argument that they could raise?
Yes.
Or did the court, because the court may have examined the question and decided that there was not, in fact, a threat of torture or cruel, inhuman, or degrading treatment. We need to know.
One of the female of the Kurds from Syria is seek help from to the Taiwan Association for Human Rights, and then get a lawyer from the Legal Aid Foundation. So the Legal Aid Foundation, the lawyer submit her situation and said that her husband was in France and already get a refugee status. They want to be reunion with her husband in France, so that's why she used a fake passport and go through Taiwan. So it's already stated in the lawyer's submission to the court. But however, it's totally ignored, and yeah, the judges still make the decision and ask all of them to deport. Yeah.
But did the judge rule that there was no danger, no risk of torture, or did the judge rule that that could not be legally an objection to expulsion?
The judges said because the female doesn't have any relatives in Taiwan and she doesn't have any reason and the legal visa to enter Taiwan, so that's the reason the judges made the decision to deport them.
But that doesn't answer my question.
Yes. So it means the non-refoulement principle has not been applied, it has been raised, but the court didn't take it up.
Yeah.
But I mean, I understood that she was not sent back to Syria, she was sent back to Malaysia.
Yeah, the last destination. Because they transfer through Malaysia to Taiwan, and they want so that's the reason, that's why our government said they didn't send them back to Syria, so they didn't violate the non-refoulement principle. But actually, because there are 5 cases, and one of them, after they be sent back to Malaysia, one of them is the elder male, he back to Syria. And the others, they find other ways to go to Europe.
Okay, yeah?
Yep, I was going to continue to say what Shinyi was talking about. It's a case about deportation of Tibetans. And in one decision, which is the Supreme Administrative Court in 2020 May, which the court recognized that principle and said that since we have already domesticated the 2 covenants, that principle should be recognized. So it was recognized by some judges. So the case was sent back to a trial because it was ruling that the executive order to deport them was ineffective. So they now have to go through a different court. But at that court, in the first hearing, they lost the case. So now they have to go to the second instance court. So in fact, there was some court that recognized.
And they recognized it under Article 7 of the Covenant, or was just saying in general the 2 covenants include the principle of non-refoulement?
It referred to General Comment number 9 of the CCP.
Okay. Anything else? Because then we should go actually to Article 14, Administration of Justice, but I recognize you, please.
Good morning. This morning, the government's response to the recusal of judges. In fact, when it comes to judges' recusal, there are 2 requirements. First, the judge must be the presiding judge in the previous trial. At the same time, he is also the presiding judge of the current trial. But it has happened on many occasions that the participating judges in the higher court still, well, who already participated in the previous trial, but still served as a presiding judge of the higher court. I think this would have an impact on the impartiality of the judge. So we should take stock of such cases where the impartiality can be called into question. Speaking of retrial, in terms of administrative remedy, there's a 5-year limit. As a result, transitional justice cannot be pursued. In fact, we are talking about abusive power by the public sector, so the time limit should not apply in such administrative litigations. It should follow the example of criminal cases. There's no statute of limitations. As for substantive fair trial, in administrative litigations, people go through the trial in the court, but basically, only the administrative decision will be changed. However, the original administrative disciplinary action will not be removed. As a result, the substantive fair trial cannot take place. So we believe the administrative court's decision must be binding on the original administrative disciplinary action. Otherwise, people would not have the right to a fair trial. Lastly, on the restrictions on leaving the country, when the case is still pending, the litigation has not yet taken place. In other words, the judicial system is not kicked off yet. The executive branch already has the power to restrict people's right to leave the country. As a result, people would not be able to enjoy their right to work in other countries or returning to this country. And once they arrive back in Taiwan, they may be restricted from leaving the country again. So this has a huge impact on people's rights. So the executive branch has too much power in this regard. So I am Ming Ru on behalf of the Judicial Reform Alliance. There's a question about the DNA Sampling Act and the DNA evidence preservation. The government says that this DNA Sampling Act is already in force. However, so far, there are only 18 applications of that act, but only 3 are accepted, and the DMAs are actually sampled. But in other cases, the samples were not collected or were not kept properly, so the DNA sampling and identification could not take place. So we believe in the COR. Government should be advised to set up a dedicated law and regulation to oversee the collection and preservation of DNA samples. Government says there are relevant laws and regulations, but we believe a dedicated regulation is in order so that the defendant's right to seek remedy would not be violated. Secondly, people's right to appeal under Article 376 of the CCP The government says that there has been an amendment to the CCP regarding that article. However, we know that every year there are over 300 cases where no remedy can be sought yet.
Thank you, Mr. Chair. 我想要补充刚刚
I would like to talk about the right to fair trial and what you may include in your concluding observations and recommendations. That is, we don't think the government can use the 5-year limit to deprive people's right to remedy. Once a decision is made, a judgment is made, but if there's new evidence found beyond the 5 years after the judgment is made, then there's no chance for people to apply for a retrial. I don't think this is correct. We hope this can be included in your concluding observation, since it's a violation of the rights under the covenant. Also, the criminal court and the civil court and their application of the 5-year limit have resulted in a lot of cases of injustice. So we believe the Transitional Justice Committee should look into this situation. Moreover, the executive branch may use their power to tax, to suppress certain groups of people. The two covenants should protect people from the abusive exercise of the taxation power by the executive branch. Thank you. Thank you, Chair. I am Lin Ziwei, speaking on behalf of the Alliance to End the Death Penalty. First of all, in response to government's reply this morning, in terms of the recusal, there are 38 death penalty inmates, death row inmates. Most of them have gone through trials where they experience the same judges in different levels of courts. In addition to Qiu Heshun, there's also Wang Xingfu, who is the oldest death row prisoner in Taiwan. There have been 9 trials in his case. In fact, 4 out of 9 saw the same presiding judges. And I think this is a violation of Article 14, Paragraph 1 of the Covenant. So that's about the recusal principle. Secondly, in terms of the preservation of evidence, government officials said that in accordance to the Archival Act, certain files must be kept permanently, but in practice, take Wang Xingfu case, for example. Last year, My Alliance and other NGOs worked together, appealed to the highest prosecutorial office for a retrial, but we were told that the evidence is gone. There's no more recording. Audio recordings are gone. And the police precinct has been relocated, so all the recording files are gone. But you heard the government officials say this morning that this evidence and files must be kept permanently. But then we were told, sorry, there's nothing we can do. We do not accept your request. And of course, for those who should be held accountable, there should be punishment. But the whole thing is a violation of Article 14, Paragraph 5 of the Covenant. Since the evidence is nowhere to be found, there's no chance to ask for a appeal or retrial. Therefore, we believe in the concluding observations, it should be indicated that if this judgment is in violation of the two covenants, there should be a chance for the defendant to apply for a retrial. Moreover, what the government didn't say, but we think is important, that is, next year, January next year, we are going to have a National Judge Act that is going to come into force. There will be 3 professional judges working with 3 lay person judges. So the sentencing decisions will also be decided jointly by the judges, including death penalty. However, it's not a consensus-based decision. Rather, as long as 2/3 of the participating judges believe the death penalty should be imposed, then the offendant will be sentenced to death penalty. So we believe before the National Judge Act comes into force, there should be room for further discussion.
There's a second question to this act. We have seen in the simulated court sessions with lay judges or lay persons, and when it's time to vote, we think professional judges are leading the lay people because they vote in a small room. In that small room, there's no any audio recording or video recording. So if the defendant wants to appeal, then there is no evidence to be retrieved. So we think according to the lack of unanimous vote for a death sentence, I think the fact that there's no recording in the small room where they deliberate, this is another issue. It also violates Article 14 of ICCPR. Hi, this is Taiwan Association for Human Rights. I want to talk about privacy. Is that okay? Okay. I want to respond to what the government said on an EID mentioned by the Household Registration Agency. What he didn't mention is that originally EID required the mandatory storage of personal information and the photo of the person. And there are no regulations that stipulate when the photos of the persons will be scanned. So currently, the abuse of the IDs is very common. If you go to some restaurants, they say, okay, if you show us your ID card to prove that you meet our discount conditions, we'll give you the discount. And without laws and regulations, and it is possible in the future the restaurants can use scanner to scan our EID and get all the information. Not only EID. During the pandemic, we've seen some local governments that wanted to promote digital ID, like Taipei Tong. And for example, citizens want to apply for a new library card, and the local government says that, okay, you need to sign the statement saying that you want to get a digital ID from us, and then we can issue you the library. The Taipei city passed a city regulation on digital ID, and then NGOs opposed to that, but that policy has not been changed. I think to guarantee that everyone is entitled to public services, we think digital ID shouldn't be a prerequisite to access public services. And I want to respond to the National Development Council because they say that Personal Information Protection Act is enough to protect personal privacy. But in this act, what I see is that, there are the use of the information for other purposes which are not known to the person who owns the information. And the threshold is quite high. It says that as long as the government agencies are carry out their legal obligations, then they can still use the information for other purposes without specific authorization. Some sensitive information, such as medical records and prior criminal record system. So the medical records of ours that are kept in the national system are for the purpose of insurance. However, this information, since it's all in the database, it can be used, or it may be used for other purposes, for example, for academic research or for the industry without requesting for consent first or giving the opt-out choice of the people. It's been 10 years, and this issue was only discussed starting from last week in the Constitutional Court. And the Personal Information Act hasn't been amended for 7 years. I think it is very difficult to rely on the amendment for this act to comply with ICCPR. Another thing, I want to talk about a large-scale collection of personal information during pandemic. Okay. Government agencies may retrieve users' information from some service providers. And the government didn't inform the information owners. There is a Telecommunications Security Act. Maybe it can be applied to telecommunication providers. And there was a case when a person's insurance card was registered with a note saying that this person is a high-risk person. But why is that? Because he or she lives in a specific area, and this person wasn't even aware of this fact. And without knowing that, this person doesn't even know why he or she was rejected in medical service in a hospital, because it was because his or her card was added at a comment saying that this person has high risk of infection. So when the government asks for such information for telecommunication service providers, the government doesn't inform the individuals. Without knowing that, the individuals, of course, do not know that they should access remedies. And Taiwan Association for Human Rights has been proposed that the government should let people know when the government is asking for personal information from service providers. They should also let people know that on what legal ground that they're getting such information, for what purpose. Well, some government agencies do have statistical data on their usage, but some other agencies, especially police agencies, refuse to release such information. Well, you may ask them, or you may ask MOG. Upon being asked, they may provide such information, but they don't always tell you. We may not know how many times they ask for such information. and so on, especially getting the information from telecommunication providers.
First of all, we are over time already, so we really have to come to an end. Second, do you have the information that you now provided in writing? If so, please make it available to us, because there was so much information in there on data protection. Yeah, thank you. I have still 3 speakers, and then we really have to come to an end. You were the first one.
Thank you, Chair. I represent the Chinese Association for Human Rights in Taipei. I'd like to a little bit elaborate the previous discussion about the excessive power of administration discretion and try to link it to the religious rights. And I do submit the question sheet about the religious right already. Even the government declared that the government tried to commit to protect the freedom of religions, but actually...
But where does it fit now? Freedom of religion comes later.
Yeah, I know,
yeah,
but...
So
can we
go, because we really have no time. Freedom of religion is in the afternoon.
Yeah, later,
yeah?
The next.
Please.
Okay, I want to talk about the Article 17条关于隐私权的部分。那特别
I want to talk about privacy under Article 17, especially respond to National Development Council. They say that it's not invasive, so it's very convenient in controlling people in the post-pandemic area. In the government session, the government was asked, what's the legal ground? And they didn't have any legal ground. They don't have any laws and regulations. According to what we know, no laws or regulation allow the government to use facial recognition in their enforcement. They rely on some guideline or some internal measures, but these are not laws. We think facial recognition is full of faults, insufficiency. It may lead to discrimination. It may be a tool used for a massive control. So we think that facial recognition should be forbidden to use in law enforcement.
Thank you. Please.
May I respond to concluding observation and recommendation 72 about the transgender right? In Taiwan, young people learn from textbook. Okay?
I think transgender right in what?
Transgender right, yes.
Under Article 17.
Yes, 72.
Of what?
Concluding observation and recommendation 72.
But in relation to which article of the covenant are you talking?
Article 17.
Yeah?
Yeah, Article 17.
No, Article 17 is now. That is. Okay, please.
I will make it short.
Yes,
okay.
and
Thank
if you have it in writing, also provided it in.
Okay, later I will write some more information, but now I make a short speech.
Please.
Okay. Young people learn from textbook in school that if they don't want to live with their biological sex, they can receive gender reassignment surgery in the future. But the textbook never mentioned the harm and complexity of the surgery. More than half of people with gender dysphoria have psychiatric diagnoses such as anorexia, autism, depression, post-traumatic stress disorder. 19% experience sex abuse during childhood, according to the research of American Academy of Pediatrics. Government should ensure specialists give transgender people best diagnosis and treatment, and the patient should be supported. We always recognize every individual, but that means we recognize the whole person, and the whole person is not necessarily one path, not only one way. I mean, it has many paths. But science evidence show that biological male sexual arousal is driven by testosterone and is far more visual in nature than female arousal. So biological men are vulnerable to being sexually aroused by appearance and visual stimuli.
trans women without surgery with high testosterone concentration in their body still can be driven by such biological impulse. Put trans women and biological women in such a situation that they may encounter each other unjust may result in unexpected and uncontrollable consequences.
But I think you're reading,
my suggestion is
out.
the government
just
should
give it to us in writing. I think that's much easier because we are really over time, and I'm very.
But I want
grateful.
just last sentence. Please listen to transgender people more widely, including transgender men and transgender regrets. Thank you.
Thank you. Thank you. And you're the last one, and we have to stop the discussion. Please, quick.
是，谢谢委员。那我很高兴刚才。
I'm glad that the government officials and the reviewers talk about the right to privacy and Article 17. I would like to comment on Article 17 and COR point 72. There are some facts I would like to provide you. We agree gender identity, sexual orientation are also privacy, and they should be protected in the right to privacy. So first of all, we talk about EID. In Taiwan's existing ID cards, there's one section indicating one's sex. There's only female or male. It's a binary system. There's no third option for you to register your gender. That's the status quo. Second fact, so far in Taiwan, if a transgender person wants to change his gender registration status, he has to go through the surgery to remove his sexual organs. And with the certificate indicating he has undergone the surgery, then he can apply to have his gender changed. Without that proof, his application will be rejected by the household registration department. So what I'm trying to say is, in 2017, the review committee, in the concluding observation with regard to point 72, the government in Taiwan has not withdrawn the requirements for surgery as a prerequisite for change of gender status. And this morning, and then in government's response, on page 205 and 206, and also on page 104, in government's response to the COR, government says that they are working on a draft. However, since then, no action has been taken in this regard. And point 206, it said that in 2018, there was discussion about the option of the third sex on the registration of one's gender on the ID card. Again, no progress at all. So I hope in this year's COR, you can remind the government that their plan proposed in 2015 should be promoted. And also, in the first list of issues, the government replied in the wrong way. The Ministry of Health and Welfare in Taiwan is supportive of the abolition of the surgery as a requisite, but the MOI uses an administrative order to request transgender people to go through the surgery to remove their sexual organs before they can change their gender status. Again, we hope in the COR, you can tell Taiwanese government to remove such unnecessary restrictions. As for testosterone, Well, I think what the previous speaker said is really just bias. Many people consider transgender women as potential rapists. That's bias,
自由度开放的国家。
我们没有把所有的男生当作潜在的性侵害犯。
Grateful to our interpreters that they were working
我们没有
overtime.
把所有的男生当作潜在性侵害
Also to
犯。
our sign language interpreters, I'm very grateful for all your assistance. Sorry that we are always under time pressure, but I know that many of your interventions also have been written down, and if not, then please provide them also still in writing. We now break for lunch, and we see each other again later in the afternoon. We start at 2 o'clock again with the government on the next articles 18 to 25. Thank you.
谢谢各位贵宾的与会，本场次到此结束。本场次会议备有餐点，请至1010用餐区领取。下午的会议为公正公约第5场次，与政府机关之审查会议将于2点钟开始，与非政府组织之审查会议于5点20分开始。将请出席政府机关人员准时与会。有关洗手间的使用部分，因10楼南侧为国际审查委员专属厕所，请勿使用。有使用需求者，请改至11楼使用。谢谢。
我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制， 并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。 台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。 9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权 是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾 是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。 9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权 是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾 是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制， 并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。 台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制， 并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。 台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。 九大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。九大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。九大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。九大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。九大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。九大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性。
Begin Cluster 5 of the ROC 3rd ICCPR report review meeting. Please be seated and turn off your cell phone or turn it to the vibration mode. Thank you.
贵宾午安。2公约
Good afternoon, ladies and gentlemen. Cluster 5, review of Articles 18 to 25 and concluding observations 73 to 77 is now in order. We are about to begin momentarily. Please make sure you raise your hand before you speak up so that the chair and reviewers know where you are seated. And when you speak up, please identify yourself, your affiliation, your name, and make sure you speak at a reasonable speed so as to facilitate the interpretation. Now, the cluster 5 begins. Thank you, Chair.
Thank you very much for your introduction. Welcome back to the last cluster 5, which contains a number of interesting civil and political, more than political rights and freedoms, from freedom of religion to speech, assembly, association, to the right to participate in the public and political life of a country. So we are going in this order, and we have divided these rights among all of us. So I first ask ROC to start with freedom of religion, please.
Thank you very much, Chairman. I think the religious rights to religion, it's one of the very fundamental rights. I think I would like to draw some attention here because there are some inputs, feedbacks from civil society regarding the freedom of expressions of religious followers during the pandemic, and there is also the religious act, if I believe, yeah? There is, let me check again. If it has been adopted or not, let me again check my, yeah. There's also the questions of if this, if there's any details of these draft religious group acts and whether there has been effective mechanisms in terms of consultations with the groups, the religious groups, when developing this policy. I think that's very, very important information that we can get at this point. Thank you very much. So there's two, the Religious Act, and then the first one was during the COVID, because there's the restrictions of gathering, and if you want to go to church, it's the mass gathering. Thank you.
MOI, religious group, and the Minister of Health and Welfare will talk about the situation under the pandemic. So I speak on behalf of the MOI. I'm Zhang Ling. In response to your first question, the Religious Group Act, has that been adopted? Well, in 1953, there was already a call to formulate a law on religious group, but there has been disagreement among stakeholders, so the law never came into being. So in the year 2001, the MOI already proposed a draft. But again, legislators did not agree on the draft. It has not been adopted. As for the Religious Group Act, whether or not there has been consultation with stakeholders or religious groups, experts have been asked to take part in the process. In the year 1991, the MOI already set up a consultative committee for religious matters. Committee members consist of members from the religious community, and there is a particular ratio divided among different religious groups, plus researchers on religions. They serve as the committee members. So whenever we propose any new drafts, we consult these committee members to seek their input. Moreover, when we felt that we were ready to once again discuss the issue with the religious community, we organized 10 seminars asking representatives from different religious groups to participate and contribute their opinions. That is when we first began planning for the draft Religious Group Act. But still, the direction of the draft is under dispute among different religious groups. So this act has not been adopted. Secondly, under the pandemic, how the activities of religious groups have been affected by the pandemic. Again, we follow instructions given by the Central Epidemic Command Center and perform reviews on a rolling basis, because gatherings of religious groups may result in clusters. That is why we would abide by the measures formulated by the CECC to prevent the spread of the virus. So far, the gatherings of religious groups have not been subjected to more stringent restrictions, except for temperature taking, masking requirements, no drinking and eating in the venue where such gathering takes place. So religious activities can still take place as normal. The Ministry of Health and Welfare, please. The Ministry of Health and Welfare speaking. During the pandemic, for religious groups' activities, I think the restrictions and limitations are just like what you have heard from my colleague from the other ministry. We try to prevent clusters of people. So generally speaking, in principle, we would like to see the control on the movement of people, and masking requirements must be met so that such activities can take place. We also issue press releases to inform religious groups about these rules and requirements, and they can also submit proposals asking if they would like to organize large gatherings, and they can still organize large gatherings.
This is last follow-up question. So, since the Religious Group Act hasn't been finalized because of the lot of contention, right? Disagreement between stakeholders. What is the plan in hand of the government now? If it's going to push through, or you still need to wait for some time, wait for this pandemic to get over, and then you will start again the consultation process, or what is the plan now?
again, on behalf of the Ministry of the Interior, our plan currently is as follows. We found that the content of the draft Religious Group Act is very wide-reaching, far-reaching, including organization, personnel, and financial aspects of religious groups. The reason why stakeholders have controversies or disagreements is they hope there will be some adjustments to the proposed provisions of the Act. And in our internal discussions, we continue to discuss and make necessary adjustments. But in the future, if we want to adopt the Religious Group Act, I think we still need to seek more support from these groups. On the other hand, we also want to help the religious community to solve certain issues, such as the organization and personnel issues can be solved first before we address the property and financial aspects. In other words, we may not be able to address all these issues in one act, but over time, we can help religious groups to address these important issues one after another so that they can legalize their property holdings and land holdings over time. Thank you.
Yeah. Again, this article in this covenant is talking about the ensuring that all people who believe in particular or one or two religions, because some people, they say they believe in many religions, will have the freedom to practice. It is not because they are having religion, particular religion, minority or majority, they feel threatened. I think that's the fundamental meaning of this covenant, this particular provisions. So in administering the rights, the human rights, we have to make sure that we are not actually creating barriers and limitations. And because that's sometimes the origins of objections. People feel like, oh, you see, you want to protect us, but you are actually limits us. So I think these are the things that we need to have, especially the parliament, the government will need sometimes to discuss with particular stakeholders, especially those who will be targeted with this Religious Group Act. I think that's my last comment. Thank you very much.
Can I perhaps also raise one question? So if I understand correctly, since there is no Religious Group Act, all those 22 main religions have been officially registered in accordance with the Civil Associations Act. Has there been any religion that applied for registration under the Civil Associations Act been denied registration? And if so, which one and on what grounds? And in that relation, have Jehovah's Witnesses ever applied for registration? And if so, what was the reaction of the government or of the authority applying the Civil Associations Act?
The Ministry of the Interior, in terms of the Civil Association Act, social groups, currently for religious groups, some would fall under the purview of the MOI. Some are religious groups, not social groups.
下面在
In many civil associations or civil organizations, there are thousands of them which have religious elements or they are of religious nature. When they assemble or when they ask for registration, did they encounter any barriers? As you ask, well, currently, according to Civil Association Act, it's the approval-based system. And now we want to promote another system which is registration-based system. Currently, when civil associations want to be recognized, as long as they follow all the laws, as long as there are 30 adults, then the only review is document review. And we ask the competent authorities to express their reviews. In fact, in most of the cases, there isn't a great barrier to any new civil associations. Should they, if they want to be created, there isn't too much problem.
Could you please reply to my questions? Has any religious group which asked for registration been denied? If so, which one? And have Jehovah's Witnesses ever applied? And if so, what was the reaction?
Are there any this kind of cases? I'm from MOI. Let me add by saying, well, maybe I should give more details. For civil associations or social associations, there are very few cases where they are forbid to be created. As long as they meet the formality requirements, they can be approved. As long as there are 30 people who engage in the preparation process and they have all the documents in place, then associations can be established. But as I said, some civil associations are of religious nature, but in practice, if they don't meet some of the elements, we return their case. It's not that we deny their case. We return the case, ask them to supply sufficient documentation. Currently, civil associations and social associations prosper very well in Taiwan. Monthly, there are hundreds, and so in a year there are thousands of new associations that are created. By this speed, I would say that the growth rates of this kind of associations is 5 to 10% every year. So central government agencies do not have any improper intervention. As long as they meet the elements, then they can be established. So Chair was asking, were there any cases that had been denied? If there are such cases, can they issue petitions? That was the question. Oh, okay. Usually we return the cases and ask for extra documentation. Based on what I know, there are no civil associations of religious nature. Well, I think I have to clarify something. I am talking about social associations which have religious elements or religious nature. Religions are prosperous in Taiwan. There are Christians, Catholic Church and these kind of churches create associations very regularly. So based on what I know, as long as they meet the elements that are required, they can all be established. Right, okay. How about petition or remedies for denied cases? We ask them to supply more documentation because we have a very open attitude toward creation of civil and social associations. When it comes to petition, usually it happens after they are created. So in the preparation process or preparation stage, I would say that as far as I know, there were no petitions at issue. And there are some controversial debates, but not for religious groups. But maybe it happened to other kind of civil associations, but not religious associations.
If I read statistics are prepared only on religious groups that have been officially registered. As a lawyer, I think always a contrario, so there must also have been religious groups that have not been officially registered. But that seems either you don't know or it seems not to be the case. So with that, I'm passing on to William Chavez on the right to freedom of opinion, expression, media, etc. Please.
Thank you. I just, before we finish with Article 18, I did a quick Google search on Jehovah's Witnesses, and the Jehovah's Witness website globally talks about a community of, I think, 10 or 15,000 Jehovah's Witnesses here in Taiwan. It shows photographs of them proselytizing in markets and so on. So it looks as if there are Jehovah's Witnesses and they're operating as they do in other countries. So I don't think there's an issue there particularly. But why they're not on the list and why it surprises me, they must be registered.
They're not on the list, so I guess they are not officially registered.
Yeah. Who knows? Well,
yeah.
Okay. Let me move then to Article 19. Actually, I have both Article 19 and Article 20, which are really linked together, and I guess I'll do them both at the same time. The report, the third report on the International Covenant on Civil and Political Rights, under Article 19, provides us with a list of various criminal law provisions or penal law provisions that infringe upon freedom of speech or freedom of expression. And they provide a justification for them. They explain on what ground they are justified, and it seems that this is an attempt to address the issues that arise, particularly from paragraph 3 of Article 19, which requires that any infringement on the right be based in law and have justifiable grounds. So I think some of them, they raise red flags about the danger of violation of freedom of expression. But absent more information about their application, I don't know how to get into this in any greater detail. It's not uncommon to find archaic provisions dealing with freedom of expression that are in fact not regularly applied, and without knowing more about them, I think it's hard to examine this in any great detail. Obscenity is an issue that has raised great difficulty before bodies like the European Court of Human Rights, as well as the Human Rights Committee. But I think that if there were serious problems with them, we would have NGOs who are before us. Perhaps we will later in the day, but we would hear more about them. So I don't feel that this is very useful to pursue this in this session. With one exception, I note that in the recent independent opinion from the National Human Rights Commission, they focus on one of these provisions, which is Article 309, Paragraph 1 of the Criminal Code, which provides that a person who publicly insults another should be sentenced to short-term imprisonment or a fine of not more than $300. I find this to be an extraordinarily unusual provision. I think probably in my career I have undoubtedly violated it, not in Taiwan, but elsewhere, by publicly insulting people, some of whom deserved it. And if I knew that the fine was a maximum of $300, I don't know that this would be a deterrent. I might be prepared to pay for the pleasure of insulting them publicly. But I suspect that this is not. I think that the issues that are raised by the Commission about the vagueness of it are very logical, but if it's not in fact being applied in an abusive manner, it's not worth exploring in greater detail. And it's not likely. One of our concerns, even with provisions that in theory threaten freedom of expression, but in practice are not applied, is that they may still have what we call a chilling effect on free speech, on freedom of expression. But as I say, I think if this was a genuine problem, I would expect we'd have more information and complaints about it from civil society. The issue that we've raised in the issues concern the very immediate problem raised by the COVID epidemic and the limitations that may have been imposed with respect to the COVID epidemic. And we've had, in reply, information that there have been what I think is a very significant number of prosecutions for this offense of spreading rumors sufficient to affect public tranquility. So this is an offense that's in the Social Order Maintenance Act. It's not in the criminal code, and presumably that means it doesn't have the same consequences as the criminal code. Nevertheless, it seems to be quite a high number. In my view, we are also told that there have been no prosecutions of journalists or media for this provision. But it leaves one wondering what exactly this consists of. We're told that in 48 cases, people were fined for spreading rumors about COVID. We've all, of course, experienced a huge amount of debate about COVID. And in my own family, there's a spectrum of views. And there's a lot of debate about information and misinformation. And within my own family, we have what I think are improper rumors being spread about COVID. So I'm wondering how serious this all could be. It seems to be extremely important, especially in light of the issues that we raised yesterday about the very, very exceptional encroachment on such fundamental rights as freedom of movement that have been occasioned by the COVID epidemic, that these be subject to public debate. And the idea that not only could such measures, which may be entirely reasonable, but that such measures could be imposed, and yet the public would be unwilling to debate them, frightened of debating them because of consequences, legal consequences in terms of prosecutions and ultimately fines if found to be responsible, is a concern. And the information we have is not adequate, actually, to be able to assess this properly. So my hope this afternoon is that there are some representatives of the government here in the room who can enlighten us a little more about what was the nature of these violations that would lead to the 48 cases of successful prosecution of people for spreading rumors. What did this consist of? Because without that information, not only is it impossible for us to assess whether there is a problem. Well, it is. We can't do that, but it seems very unusual, and I would not. There's nowhere that I have worked and lived in the last 2 years where I've encountered any threat of prosecution of any kind for debating the COVID issues and how it's dealt with. So I hope that we can learn a little more about what these prosecutions involve. Thank you.
So the Ministry of Health and Welfare, please. The Ministry of Health and Welfare speaking. Under the pandemic, there's a lot of information, rumor, lots of news. As you said, we still have to balance free speech and the right to accurate information, and the general public should be afforded the opportunity to debate, express their views so that the government knows what difficulties they are confronting. So first of all, in the case of rumor, what our strategies are, first of all, we will distinguish whether the rumor is meant to be malicious, false, or damaging. If the three requirements are met, then according to our Prevention of Communicable Diseases Act, there are provisions to restrict the spread of disinformation about infectious diseases if they are intentionally malicious, falsified, damaging in terms of causing public panic, then that will be considered rumor. And as you may know, Taiwan for a long time had zero infections, even though the situation in other countries was very serious. Back then, Taiwan saw no infections. So then there was rumor about now there's a big cluster resulting in a high number of infections and even death. So such rumor may be spread through Line, FB, Facebook, or YouTube channels. Since we have no infections back then, many people would question if the government was telling the truth that we had no infections since the situation was so bad in other countries. That's why we would inform the general public the latest data. We had full grasp of the data about imported cases or the absence thereof. So the rumor I just described would cause panic among the public. Then that kind of information would be malicious, falsified, and damaging. And the person who spread that rumor would be subjected to criminal investigation. And I think the 48 indictment or prosecutions would fall into that category. As for the Social Order Maintenance Act, for example, if someone said that if you take marijuana, you will be able to fight COVID-19. In this case, under the pandemic, spreading such information, such falsified information about possible cure of the COVID-19 infection So the person who spreads such misinformation would be subject to a fine by the Social Order Maintenance Act. But whether it is rumor or misinformation, under the pandemic, we first clarify, making sure people know what is true, what is not true. And of course, there's uncertainty. Sometimes we need time to find out what is the truth. We will tell the people honestly that we need to gather more evidence so as to know if the information is true or not. Thank you. Good afternoon. The MOJ speaking. Thank you for the question. You talk about under the pandemic, the debate, meaningful debate over information about the pandemic. That is part of the freedom of speech. We pay full respect to that. But for violation of the criminal code to take place, that means the person, the perpetrator, knows clearly he is spreading some misinformation, fake information, with the intention to instigate fear among people. In that case, this person would be held accountable criminally. For example, at the end of January 2020, when Taiwan government first elevated the alert level to level 2, and COVID-19 was declared as a infectious disease. Back then, one person in a Facebook community with over 80,000 members spread some news, some fake information, saying that one certain hospital had found confirmed cases. When the information was disseminated through the Facebook community, the hospital is actually a very big medical center in central Taiwan, and the staff at the hospital received thousands of phone calls from the public asking if they had confirmed cases at their hospital. As a result, the operation of the hospital was paralyzed because of such fake information, fake news. And this kind of behavior is something we would like to prohibit and punish, because this is not meaningful debate about information about the pandemic. Especially during the pandemic, we have to resort to legal means to suppress the spread of such fake information, disinformation. I think that is the role of the law during the pandemic. Based on the data we provided, you can see the prosecutors have been very cautious in filing charges. They try to strike a balance between maintaining social order and protecting freedom of speech. You can see that the prosecution rate is only 7%. 60% of the people were not prosecuted in the end. In other words, most of the people's freedom of speech have been protected in the end.
The explanations. The first speaker spoke about the danger of creating panic within the population, and I'm wondering if you can give me examples of panic in the population here in Taiwan as a result of misinformation. The second speaker gave the example of a Facebook post that had apparently false information about a hospital and said that it received a lot of phone calls and that this paralyzed the operation of a hospital. I don't find that very convincing. I don't see how a lot of phone calls could paralyze the operation of a hospital. Can you explain how a hospital getting a lot of inquiries by telephone paralyzes its operation, please?
The Ministry of Health and Welfare, please. Would you like to provide some example about panic among the public? The prosecutorial office department speaking. In the case I just shared, because the information on the Facebook community said that there were confirmed cases in the hospital and the patients already hospitalized there, and the people who would like to visit the hospital for outpatient care, they were afraid. They were not sure if the news was correct. That's why they would like to check with the hospital. They called up the hospital. The hospital received a lot of phone calls, and the administrative system of the hospital was pestered with so many phone calls. They did not know what to do. The hospital tried to clarify by filing suit at the police and the prosecutor, hoping them to find out the source of the misinformation. Within 4 days, we identified the source of the misinformation, and everything was clarified. As for paralyzing the operation, well, I think it's a figurative way of speaking. How paralyzed was the hospital? I think there may be different opinions by people involved in that case. But all I'm trying to say is, in this case, the general public, the hospital, were impacted, and there is panic.
Evidence of people telephoning a hospital to inquire as to whether a rumor is true or false consists of panic or not. But I think we've probably all experienced in the last year or two telephone calls to airlines, railway companies, whatever, where human beings don't answer the telephone and you get a recorded message. So we can assess, I guess. Are there any better examples of panic in the prosecutions? If not, I'll move on.
这个案例我们再找一下。
We will search for more examples and report back to you. And sometimes it may not be panic. As we just heard, rumor may be malicious, damaging, and falsified. For example, if someone says that one chain restaurant or chain stores have been visited by confirmed cases, it's rumor. As a result, people dare not shop at those stores or restaurants. And of course, for criminal offense to be to stand, basically the general public or the common good must be jeopardized before we can prosecute anyone criminally. But if a business is impacted because of such rumor, then the common good or the public interest is at stake. However, if we are talking about criminal offense, then of course it will go through the judicial system. The judge will have to investigate and adjudicate based on evidence.
The high threshold that appears to be required and the need to demonstrate not only that the misinformation was malicious or that it was done with a view to incite a panic. But what surprises me is that there would be 48 cases that would meet such a threshold. In any case, we'll await further information if there is some. Let me turn now to Article 20 of the Covenant on Civil and Political Rights. And this is addressed in, I had it right before me. Yes, I'm sorry. This is addressed in the third report on page 90. Article 20 has 2 paragraphs. The first one deals with propaganda for war, and the second deals with what we might call hate speech. And the information in the third report addresses hate speech, which is covered by paragraph 2 of Article 20. Probably more could be said on this because there are more detailed requirements about hate speech in, for example, Article 4 of the International Convention on the Elimination of All Forms of Racial Discrimination. But my question is about the first paragraph, which is about propaganda for war, which is not addressed here. Taiwan would not be alone in not doing anything to implement the requirement in paragraph 20, paragraph 1 of Article 20 of the Covenant on Civil and Political Rights. In fact, in the recent study that I conducted for my book on the Covenant, I looked at how much in the state party reporting, how much evidence there is of this provision being implemented, and of how much oversight has been provided by the Human Rights Committee. And the evidence is quite underwhelming. There's not very much evidence of the provision being implemented. Nevertheless, it's in the Covenant, and I think it should be implemented. And I think particularly in these recent months when we have an example of an international armed conflict, a relatively rare occurrence, it must be said, but it reminds us about the importance of the International Covenant on Civil and Political Rights in promoting peace. And this is one of the ways it sends that message, is by requiring states to prohibit propaganda for war. And since we're in the area, and we see this in the other provisions on freedom of expression that limit freedom of expression, that some of the provisions are more didactic in nature. They may not be applied often. They nevertheless convey messages to the public about what should and should not be said. So I don't know if there's an answer or an explanation on this. I rather doubt that there is, except to observe, as I did, that there's nothing on the subject in the laws of Taiwan. But I think it bears mentioning that maybe there should be, and that it would be a simple issue to address with a legislative change. But I'm not expecting.
简单说明一下吧。
Department of Prosecutorial Affairs, do you want to respond? Hi, I'm from MOJ. And thank you very much for your question. In the written document, it probably doesn't state that, but in Chapter 2 in the Criminal Code, in Article 103, there are some stipulations. Article 107 states that if someone intend to initiate wars, may be subject to death penalty. And according to Article 153, if anyone who incite others and encourage them to start wars, and they shall face relevant punishment.
JD7 of the restrictions on freedom of expression. Thank you for the information. I'm finished.
Article 20 is a provision that obliges states to to criminalize certain behavior. The one is war propaganda, and I think we just got this information. But the other one is incitement, advocacy of national, racial, or religious hatred. And I'm now looking at the replies to the first list of issues, number 43, where the government then says that Taiwan's religious diversity index ranks second in the world, etc. But then it says there's no provision addressing advocacy of national, racial, or religious hatred in the Immigration Act, which is enforced by the Ministry of Interior. So I was a bit puzzled by this sentence because, first of all, I'm not quite clear why this should be in the Immigration Act and not in the Criminal Code. But also secondly, because if the government says we have not done that, then the government says we have not implemented our obligation. So can I verify that? So is it true that this part of Article 20 has not been implemented?
MOI. This is Immigration and Agency. In current Immigration Act, there are some provisions that prevent some people from entering Taiwan. Maybe some of the wording is not explained specifically enough. But it means that some people may have criminal records overseas. But the provision has been amended and says that if some foreigners who have committed into hate crimes and so on, then they must not enter Taiwan. But that amendment is still being reviewed at the Legislative Yuan.
Might be the case, but this is not what Article 20 requires. So it's not a provision that only applies to foreigners. It applies to everybody. Nobody should actually advocate national, racial, or religious hatred or violence. And this is not only a legitimate restriction of freedom of speech or freedom of the media, it is actually the other way. It is an obligation. You have to restrict freedom of speech in order to protect people against hate speech, in particular religious, racial, and national hate speech. So can I take it that There is no provision in the criminal code. That's where it should be. No provision in the criminal code relating to advocacy of national, racial, or religious hatred. Please, I just need a confirmation.
Well, let me explain. In terms of criminal punishment, there is criminal code. There are many other codes. For example, the Act of Prevention and Punishment of the Crime of Genocide. It's a special law. So all of these penalties are criminal penalties. So in Article 2, it says that any one of the following acts committed with the intent to do this, and that shall be deemed as genocide. And in Article 3, it also stipulates that the direct and public incitement to commit the offenses stated something shall be punished by life imprisonment or term imprisonment with a minimum of 7 years. And in Article 246, in criminal code, there is a public insult punishment to religious groups or facilities. So if there is public insultation to temples, to religious sites, then these people shall be punished. Or people who intervene with religious worships and so on will also face criminal penalties. And along with Article 153, if one incites others to engage in insults or to intervene with religious burial or religious rituals, then they should also be subject to punishment.
Thank you very much. Has this also been written somewhere? Did I overlook that? Or because I couldn't find. I mean, the genocide, the Prevention, Taiwan's Act of Prevention and Punishment of the Crime of Genocide, yes, that is immediately, there's a paragraph 1 under number 43. But of course, that is much more serious, no? If I direct and publicly incite to commit the offense of genocide, that is a very serious crime, and you also have, you're punishing this by life imprisonment. But incitement to racial or ethnic or national or religious hatred is something different. But thank you very much. Final point, Section 309 of the Criminal Code makes public insult an offense, and the National Human Rights Commission, I think rightly so, criticizes this as being very vague, extremely broad. So the recommendation, kind of the National Human Rights Commission, is it should be subject to a high criteria in examination. And it's necessary to review it against the principle of proportionality, because it's very, very unclear. Not every insult should be necessarily a criminal offense. So is the government willing to react to the criticism of the National Human Rights Commission, which I should say I at least personally share? Thank you.
Basically, we believe the freedom of speech should take priority in order to protect freedom of speech. since now we do have the Act of Prevention and Punishment of the Crime of Genocide, which involves harming groups of people. But according to Article 153 of the Criminal Code, if you incite people to bully or hurt other groups of people, that is also a criminal offense. Right now, we are looking into enacting an anti-discrimination legislation. Do we want to have a dedicated legislation, or we can refer to the different offenses in different regulations and compile them and classify them into different offenses as discrimination?
Certainly, I think it doesn't matter where it is, but it needs to be a criminal offense. That's the only point. If that will be part of the equality and non-discrimination legislation, I think that's certainly also a possibility, because it has to do with discrimination. Does that conclude our discussion on Articles 19 and 20? Then we move on to Article 21, and that is Per Lorentzen, please.
Is it? Yeah, thank you very much. I would like to address the issue of the Assembly and Parade Act, in particular concerning its Article 29, which the government already almost 10 years ago, in 2013, acknowledged is in breach of Article 21 for various reasons. There is an approval system which should be replaced with a registration system, the powers of the police, proportionality, and various other issues. In 2013, this review committee recommended that it without further delay be adopted. And in 2017, the committee expressed its grave concern that the necessary amendments has not yet been adopted, and that the Article 9 was still in force and being applied. We know that in January 2016, that's now more than 6 years, a draft was presented in order to remedy the situation, was presented to the legislative yuan, and it is still pending. So I would like to ask first what, so to say, is the actual situation of this draft, and what are the prospects that it will soon be adopted by the legislative yuan. Secondly, as we said, that there are various issues in the present legislation that needs to be corrected, as it is stated in the concluding observations we made in 2017. The question of non-use of abandoned use of penalties, and to replace the permit system with a reporting system. And as far as we are informed, this draft, which has been presented, should remedy the situation in this respect. But there are other issues, as it was pointed out, which need to be corrected. And the question is that so? Does the draft comply in all aspects with what has been recommended?
The MOI Good afternoon. The National Police Agency, under the MOI speaking. In 2013, the review committee came here asking the Legislative Yuan to amend relevant laws in the Assembly and the Parade Act that are not in compliance with the covenant. In response to your question, in 2016, we successfully presented the draft amendment to the Legislative Yuan. That year, legislators had a lot of discussions of the draft amendment. Of course, legislators represent different sectors of our society. They speak on behalf of their constituencies. In the end, we had a draft Assembly and Parade Protection Act. This Assembly and Parade Protection Act is a product of compromise, but at the end of 2016, there's no further discussion and progress on the draft. I think it's because we try to replace the authorization system with registration or notification system. On this regard, some law enforcement agencies and legislators have concerns and reservations. So this draft in 2020, because we had new legislators taking office that year, as a result, the bills that were not finalized in the previous session would be sent back to the executive branch that proposed them in the first place. So right now, the executive branch, has the court, the ball is in the executive branch's court. The executive branch's proposed draft is quite different from the proposed Assembly and Parade Protection Act discussed in the Legislative Yuan. So given the gap, I think more compromise and negotiations are in order. In 2013, we promised to the review committee that we would reform in the following direction. That is, there will be replacing the authorization by notification, narrowing the scope of ordered dispersal with relevant limitations provided. There's no more criminal punishment. That is for sure. The second question, you talk about some deficiencies in the existing act. Yes, the executive branch is still working on the draft based on your recommendations. We have been working closely with scholars and experts from different countries to help us to fine-tune the draft. Hopefully, the draft we submit to the Legislative Yuan will be read and reviewed as soon as possible. Thank you.
Questions on Article 21 and 22? So am I kind of correct also that the discussions about the Assembly and Parole Act have kind of been superseded by the Constitutional Court, so that you, since the right to hold urgent and spontaneous rallies without any kind of authorization or notification is now being granted by the Constitutional Court. It's no longer that important that you replace the authorizations regime by notifications, because anyway people can just go out on the street without even notifying. Or are you still really working to have an amendment of the Assembly and Parole Act so that the usual way would be that demonstrations and other assemblies will be duly notified to the authorities?
Good afternoon. The MPA speaking. In response to your question, yes, the Judicial Yuan interpretation number 718 already provides guidance. And so my agency has taken action to amend the Assembly and the Parade Act for urgent and spontaneous assembly. Restrictions should be reduced. However, it takes time to amend the law. That is why we have implemented an administrative rule for spontaneous gathering. There's no need to apply. But for urgent rallies, basically, according to the existing law, the rally attendees still have to notify the police authorities. Basically, once they submitted their application, we will right away give our approval. So before notification replaces approval system. This is our practice right now. The Constitutional Justice or the Judicial Yuan interpretation number 718 did specify that starting January 1st, 2015, the restriction on urgent and sporadic rallies have been removed. That is why we have different mechanisms in place to deal with the situation.
If I'm saying something which is already public knowledge and we all know it, but maybe I missed something. This article is talking about two things in my opinion. One, it is the freedom of the right to associate rallies or gatherings and so on, to come together to discuss at a public level. But the other point that I see is the right to form and join trade unions for the protection of workers. So I haven't heard much about the trade union situation here. So I just have a very simple question. Is there any restriction on the formation of trade unions in places of employment? And is there any conflict between employers and workers on the formation of such trade unions? In some places, in other countries, we hear of what we call union busting. If workers want to form unions, the employers immediately, there's a backlash against their worker. So what is the situation of trade unions in the country? Is it there's freedom to form trade unions and collective bargaining in those circumstances? If you can answer that question.
好，请劳动部。
Ministry of Labor. Anyone from Ministry of Labor? I think the issue on union is probably discussed in ICCPR committee. I think a representative from Ministry of Labor are probably at the ICCPR review.
I know it's double. It's both in Article 8 of the Covenant on Economic, Social and Cultural Rights and here, and it is discussed in the other committee, but all right. If that's okay for you, yes?
That's fine.
Mm-hmm.
No, it's okay. So we can go to the next one. Because if you move to Article 33, I want to raise a question on same-sex marriage.
Yes, of course. Yeah. So if there's nothing anymore on 21 and 2, then we anyway move to 23. Okay. So it's your turn.
I'm looking at Article 23 on family life and the freedom to marry and found a family. And I just want to raise one question. We hear, first of all, I must commend the government of Taiwan for registering for same-sex marriages. You know, it's something to be commended. But at the same time, there is also an exemption for same-sex marriage registration if one of the spouses is intended spouses is from another country and that country does not recognize same-sex marriage, then they cannot register, that couple cannot register it here in Taiwan. I would like an explanation of the rationale behind that restriction. Why do you have that restriction? What is your reason? Can you please explain that?
Department of Gender Equality from Executive Yuan. Thank you for your question. I'm from the Department of Gender Equality. I'm the director of the department. In the first and the second list of issues, we saw this question on transnational same-sex couples. It seems that some full protection is not provided yet, so I will explain first, and maybe later on other agencies can explain too. For transnational or cross-strait same-sex marriage and couples, well, after JY interpretation 748 passed, and we have a JY interpretation 748 Act. So if people are from a country which do not legalize same-sex marriage, then they are not covered by this act. Because we have an act that governs matters involving foreigners, and there is also a mainland affairs regulation. I think both of those regulations have to be amended before they can apply. And for the act governing the choice of law in civil matters involving foreign elements, it's about a foreigner in the couple, and another act that governs relations between Taiwan and the mainland. I think they need to be amended first. The law in civil matters involving foreign elements were already sent to be amended. Executive Yuan will need to propose supplementary measures. Executive Yuan had organized several meetings on the amendment to civil law for foreign matters. In discussing this matter with other agencies, they realized that it is necessary to also amend the act that govern the relations between Taiwan and mainland people, so that both foreigners and people from mainland China will be covered by 748 Act. The act that govern the relations between people in Taiwan and mainland is still being discussed. And MAC, Mainland Affairs Council, is in the process of discussing the details of the amendment. So maybe Mainland Affairs Council can provide their explanation. Yes, we are very active in finishing the amendment. So Mainland Affairs Council may want to provide extra information on the amendments. Also, on the issue of adoption and the right for same-sex couple to adopt children, maybe if that's also a question you want to learn about, Ministry of Health and Welfare later can provide their explanation. Thank you. I'm from Mainland Affairs Council. On the issue of cross-strait same-sex marriage, well, the civil law for foreign matters was sent for amendment last year. So Mainland Affairs Council also started its review of the cross-strait regulation, and we refer to the civil code in amending this act. In the legal process, we need to make announcement first, and last December, after we made the announcement of our potential amendments, we receive many public opinions which cover various aspects. Some support the amendment, some oppose. On the issue of same-sex marriage, various stakeholders have different opinions. So we collected all the opinions and study and review all of them. In the review, we saw some opinions toward the government or the executive branches. These opinions cover their recommendations for legal review. So we engage Immigration Agency and Ministry of Foreign Affairs to review administrative procedure and the review mechanism. In all of these processes, we need to take into account all of the public opinions. In amending the law, we need to collaborate with the Executive Yuan for overall consideration. Judicial Yuan. I'm from the Civil Affairs Division from Judicial Yuan. According to the civil law for foreign matters, well, you ask why if one party from the couple comes from a country that does not legalize same-sex marriage, then they're not covered by 748 Act. Well, this civil law for foreign matters was created 20 years ago. At the time, the society in Taiwan or internationally, or I should say most of the countries at the time didn't have very clear legislation for same-sex marriage. And our country in May 24th, 2019 had the first same-sex marriage in Asia. That is the 748 Act, which ensures marriage equality. And after the implementation act of this judicial interpretation was created, Judicial Yuan organized many meetings with external stakeholders to discuss how to apply civil law for foreign matters in case when one of the couples or one of the people from the couples comes from a country which does not recognize same-sex marriage. What will happen? Well, to resolve this issue, we proposed an amendment, sent it to Legislative Yuan for review. If it passes, then even though this person is from a country that does not recognize same-sex marriage, their marriage will still be able to register in Taiwan. That's a goal we want to achieve. MOJ? Hi, I'm from Legal Affairs Department of MOJ. Department of Gender Equality talk about adoption. And based on the Implementation Act for JY Interpretation 748, we consider that if the same-sex couples got married, they will live together, and to protect the rights of the birth child, then in our civil code, Article 201, the other person in the couple can legally adopt the child. But under the Act, or under the Civil Code, they are not able to adopt a child which is not a biological child of either of the partners. But many legislators have proposed that this is an issue that needs to be resolved. I think there's a proposal by the legislators already, and tomorrow the legislators will in fact review this proposal. And I have reviewed many similar proposals internationally, and MOJ had many consultations with experts. We issue an evaluation report to the Legislative Yuan so that when they have such discussions tomorrow on adoption, they have more information to refer to. Thank you.
Thank you for your answers, but I was not raising the question of adoption, although I'm glad to hear that your legislature will be considering the adoption for same-sex couples, and that's, in my view, progress. I'm glad, although I didn't raise the question. The question, as from MOJ, clearly understood. I'm only asking why there is an exception if one of the members of that couple is coming from a country where same-sex marriage is not recognized, you cannot register it here. That's the only thing I am asking. But I also heard, and I'm happy to hear that, that is a goal that will be resolved, and the matter is with the legislature to change that, and I think I'm happy to hear that. Otherwise, a lot of explanations that was given with mainland affairs and so on is not something that I raised a concern about. The issues are really you recognize same-sex marriage. You don't have a problem today with, in principle, with same-sex marriage. So that's good, even though many other countries are not recognizing it. Secondly, it's possible for a Taiwanese citizen within a same-sex couple to marry a foreigner. That is also possible. So that is progress too. The only area in which there seems to be a problem is that if one member of that couple comes from a country where the same-sex marriage is not recognized, they cannot register it here. That's the only difficulty you have. Telling us that same-sex marriage has not been registered or recognized in other countries and all that is irrelevant today for you, because you have recognized it. But I'm glad to hear that the matter is with the legislature. And your goal is to resolve that problem. Thank you.
Okay, then thank you very much. I think it's now 3:30, so we have been working already at 1.5 hours. So I would suggest let's have another break. Yeah, we have only 2 articles left, 24 and 25. So if you wish, we can have the break until 4 o'clock. And then we are finalizing in the next hour then the 2 remaining articles. Is that okay? Thank you.
现在是中场休息时间，待会会议开始时间是下午4点整，请各位贵宾准时回到会场，谢谢。有关于洗手间的使用，
落实平等及保障多元文化的精神，人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾 是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制， 并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。 台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制， 并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。 台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。 9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲。
Yeah, can we start again? Thanks for being back. We have Articles 24 and 25 left. So it might be that we don't need to use the full time and perhaps can start the NGO meeting a little earlier. But let's see. On Article 24, rights of children, if I look at the general population, then I see it remained fairly stable. So there's not a real population growth. In the core document, we see between 2015 and 2019, it was going up from 23,492, 23,492,000 to 23,603,000. So it's more or less stable. The female population is a little growing and the male is decreasing. But if I look at the information on children, there's a fairly significant decrease. If in the third report on Article 24, paragraph 247, between 2015 and 2019, it was steadily going down from 4,043,000 to 3.7 million. Is there any particular explanation? Does it simply mean that the population is aging? It's a fairly small amount also, a small percentage of children. Is that a problem for the government? And if so, is the government taking certain action in order to fight the decrease of the number of children?
The executive first, and then the Ministry of Health and Welfare. Thank you for the question about declining child population. Yes, the absolute number has been falling. I think this is because many young people do not want to marry, have children. So the lower percentage of children from the executive yuan's perspective is a very serious concern. And we have been collecting data, for example, education, employment opportunities, economic opportunities, housing. There are many different aspects. Actually, we have set up a strategy to combat the falling number of children. For example, education-wise, what can we do? Healthcare, childbirth subsidies, for example, and social welfare policies are also concerned with the declining population. For example, we need to provide more care centers. We provide allowances for children, for families with young children. These are efforts made to encourage people to have children and provide better quality of life for them and their children. Thank you. The Ministry of Health and Welfare. Sorry, so the executive yuan?
If I go a little bit further, paragraph 250, there are another statistics. And by the way, I'm extremely grateful to the government that you are providing throughout the report, the different reports, quite a number of statistical information, which I think is a very, very important to understand the situation in the country. You refer to the number of placement and guidance cases between 2015 and 2019. And again, there's a very significant decrease from 265 in 2015 to 146 in 2019. Again, is there any kind of explanation? Is this a deinstitutionalization policy, or what is the reason for that?
The Judicial Yuan. Table 21, the data is provided by the Ministry of Health and Welfare. Maybe the Ministry of Health can provide some explanation. Okay, speaking on behalf of the Ministry of Health and Welfare. So children in foster care and institutions. So we collect data from these institutions. Because this, of course, has to do with the decisions made at the juvenile courts. Juvenile court judges have to determine whether it is appropriate for children and juveniles to be assigned to these institutions. So maybe the frontline staff will be in the position to answer the question. Chair, if you were asking about minors assigned to the institutional care following decision by the juvenile court, and the number of such juveniles has been declining, the reason why. As far as we know, before 2019, for those aged between 7 to 18, so children and teenagers are covered. But after 2019, children, if in violation of criminal code, will not be sent to the juvenile court. Rather, the social welfare department will take care. And this, of course, is in line with the CRC As a result, the number of cases handled by the juvenile court has decreased. Moreover, in 2019, we amended the law concerning juvenile delinquents. That is, juvenile courts can work with local governments, social welfare, health department, education department to provide a platform on which they work together to provide a better environment for the development of juveniles. Maybe it's because of this platform, many juveniles' family conditions have improved. As a result, there's no need to have so many juveniles in the institutional care or foster families. But the specific reasons are yet to be researched.
I also noted with, I'm very pleased that in 2020 the Juvenile Justice Act was implemented by also moving children out of the juvenile justice system into the child welfare, Child and Youth Welfare and Rights Act, also the youth welfare system. But I mean, is this, so if you say the number of placement and guidance cases, is this the total number of children in institutions? Because guidance, placement and guidance, that also means, I guess, foster families and family-type institutions. So how many children are actually in institutions, whether it's orphanages or all kind of institutions under the child welfare system, and are these larger institutions or family-type community settings? What is the actual situation in Taiwan? Because there, in my opinion, the number looks very, very small. If these are the total number of children, would be in 2019 146 children that are placed in institutions or other forms of care. Could you please explain a little bit more?
Thank you for the question. Thank you for giving me the opportunity to explain. On the data you described, in the report, point 251, what it says is local governments, in accordance with administrative rules, provide placement. So the Ministry of Health and Welfare has compiled the data. So I said, when it comes to judicial placement, that's the situation I understand. But to a greater extent, local government provide administrative placement, providing assistance to families in need so that alternative home environment can be provided for these juveniles from those families. Thank you. The Ministry of Health and Welfare speaking. I'm here. The Ministry of Health and Welfare speaking. In Table 21, the placement at children's and the juveniles facilities and foster homes, these are the number of all institutions. 113 institutions. That's why there are over 4,000 beds in those institutions. So Many of these children are in placement because their families run into difficulties, economic difficulties, for example. So with the consent from their guardians and the parents, they are put into these institutions under the local government's care. And of course, we heard there are some special circumstances under which children and juveniles are sent into placement. Thank you.
Yeah, I'm still not totally clear how the numbers of placement and guidance relate to the number of the much higher number of placement at children's and juveniles facilities and foster homes, which are thousands. As you said, the total beds are about 5,000, and if I take all together, we come on yeah, about 4,000 or 4,500 children that are placed in institutions and also in foster homes. And I simply couldn't relate these numbers with the numbers that were in paragraph 250, which are much, much smaller. But does it mean that those are the ones placed by court's decision, and the others are simply also when the parents bring their children voluntarily into an institution, etc. So I haven't totally understood this relationship between these different numbers.
This is a Department of Protective Services from Ministry of Health and Welfare. In paragraph 250, the number is about juvenile population in the judicial system. So the juvenile court decided protective shelter for them. That's why the number is very small. Whereas in paragraph 251, in alternative services, there are 3 types of shelter: kinship shelter, foster family, and the third is institutional shelter. So in addition to the juvenile population in 250 paragraph, which were decided by the courts, in addition to that, there are 2 other categories. One is that due to family crisis, the families commission some other homes or institutions to care for their children. The second category is that there are events of abuse of children, so the family is not suitable for the children to grow. So welfare services decided with the recommendation of the court to send the children to protective services. So every year there are about 4,000 children who are sheltered through protective shelter, through family commission shelter, and through court decisions.
That explains, I think, very well what I wanted to know. Next question is stateless children, and you have an own chapter on the protection of stateless children. Can you provide me with data on that as well? How many stateless children are currently living in Taiwan?
Ministry of Health and Welfare, do you have any information on this regard? Hi, this is MOHW. I have a number from Immigration Act, Immigration Agency from 2021. We have the number of children of migrant workers. By the end of last year, there were about 1,136 children from migrant workers' family, and 715 of them have returned to their original country. 80 are being held by the welfare services, and 341 of them are untraceable. And in paragraph 252, you see the Harmony Home Association. And this is an association in Taipei helping the children of untraceable migrant workers. This association now has been fully registered in Taipei, so they can help protect and provide services to the children of migrant workers who have gone untraceable.
A reply to our first list of issues. It's the number 31. It's actually on Article 16, which we have dealt already. But there it says that the Minister of Interior will determine whether a child is stateless according to the relevant procedures, and there are different possibilities. But then it says, in order to implement Article 7 of the Convention on the Rights of the Child, to protect the children's rights to obtain nationality, the nationality law is amending in accordance with legal procedures. And it's stipulated that foreigners or stateless persons who are unmarried and under the age of 18 may apply for naturalization by social welfare authorities. I mean, this is not only in Article 7 of the Convention on the Rights of the Child. I mean, it's also Article 24, Paragraph 3 of the Covenant on Civil and Political Rights that clearly says that every child has the right to a nationality. So that means there's a positive obligation of states to, even if states like Taiwan are not following the jus soli, if you are following the jus sanguinis, nevertheless, if a child who is born on the territory of Taiwan and for whatever reasons is stateless, then Taiwan would have an obligation actually to provide citizenship to these children in accordance with Article 24. So when I am right, when I heard the statistics right, there are about 1,136 stateless children currently, and it is a procedure before the Minister of Interior. So would you actually be willing to change the procedure in a way so that you are reducing or ideally abolishing the phenomenon of stateless children in Taiwan?
Immigration Agency. This is immigration agency from MOI. For non-citizen children who are born in Taiwan, well, in fact, in 2017, there was a regulation, or there was a procedure to identify stateless people. So by March, in fact, 22 stateless people, in fact, have been issued with national ID in Taiwan. Also, we do not separate mothers and children, so we help 744 of them to return altogether back to their country. So the Department of Household Affairs and us have been using this procedure, which is working very well. So if any government agencies identify non-citizen children, they can report the case to us. Can you further explain? Can they be granted the nationality automatically if they are born in Taiwan? I think this involves Nationality Act. Maybe after this session, we will ask the Household Affairs Department to provide more information. In fact, we're here. This is from Household Registration Office from MOI. Yes, we have some procedure to help stateless children to be adopted by Taiwanese people. And we can help them apply for naturalization. Regarding Nationality Act, well, currently we use who's sanguinis, but we are planning an amendment for foreigners who are under 18 years old. Well, I was talking about stateless people, but for minors, if they enter the welfare services, and these services can help the stateless children to be naturalized and to obtain Taiwanese nationality.
These were my questions in relation to Article 24. Any of my colleagues? If not, then I would continue to Article 25. Yes, please.
I don't know if we have discussed the issue of child abuse, whether there is an experience of that phenomena here in Taiwan and how that is addressed. It may not be a stateless child, maybe not an orphaned child even, but there are two issues. One is abuse of children, including neglect, and under what law will such child be given protection, including whether they are trafficked for labor and child labor. If there's a quick response to that.
Ministry of Health and Welfare. I'm from Protective Services of MOHW. In Taiwan, we follow CRC and its principle. No one can treat children inappropriately, including physical and mental abuse, sexual abuse, violence, exploitation of children sexually, or labor exploitation, or any illegal behavior is forbid according to the Children and Youth Act in Taiwan. If there are any events when anyone illegally infringes upon children's rights, the government can directly intervene and provide protection to children. When necessary, government may help remove the children from a dangerous family and enter into alternative care, including foster family, institution, or kinship placement for better care. If perpetrators are the primary caretakers of the children, we provide parental education to help them understand how to become better primary caretakers of the children. If the perpetrators are people who are other than the family members, then we follow the judicial procedure and pursue these people through legal matters.
Quick follow-up. I have a quick follow-up, couple of questions. One is, I'm glad to hear you have the child protection services that will take care of children who are in difficulty. But do you have a child rights commission or commissioner that particularly is proactive in preventing abuse of children? In some countries we have that. Maybe you don't have the need for it, but just let me know. Do you have a child rights commission or commissioner? And secondly, when it comes to the especially sexual abuse of children, and there has to be litigation against the perpetrator, where a child has to come in as a witness to the offense or the crime, it's been found necessary in some jurisdictions to have special procedures for the child to be able to give that kind of witnessing, and even the court judges who sit on such cases are given extra training on how to adjudicate when your key witness is the child. Have you felt the need for such specialized services for children, or everything is handled quite well with your usual procedures? Just can you tell us that?
The Ministry of Health and Welfare, and then the Prosecutorial Affairs Office Department can provide more explanation. First of all, sexual abuse of children. In our Prevention Act, if children or juveniles have been assaulted and their judicial procedures would be different. For example, we have professionals to help people with the disabilities and children to go through the interrogation from the police to the prosecutors to the judges. When they face questions from these actors, children would receive help. In addition, there are regulations requiring all judges, prosecutors, and police officers to receive sufficient amount of training so that you know the special considerations they must take when dealing with cases where children are victims of sexual abuse. In addition, the regulations also provide that when it comes to the evaluation process, there are special requirements. Social workers will have to be there accompanying the child throughout the process, including taking a physical checkup at the hospital and going to the police to be interviewed, to be deposed. All the social worker will accompany the child. Moreover, in terms of sexual exploitation of children, just like the rest of the world, Taiwan's children face the risk of being exploited because of the dissemination of sexual images or intimate images disseminated online. So we have a new guidelines concerning the removal of such intimate images of children online. So we do have very clear guidelines to incorporate the spirit of relevant covenants. Thank you. The Prosecutorial Affairs Department speaking. In terms of sexual abuse of children, the Criminal Code. In May 2019, we amended the Criminal Code concerning people who abuse children under the age of 18 and cause developmental damage to them. Then there is imprisonment sentence of 5 years. If the child victim is dead, then there will be imprisonment sentence of over 10 years. So there are different in some cases, life imprisonment can be imposed. When the child is the victim of such cases, prosecutors dealing with such cases must have received sufficient amount of education. And we, at each prosecutor's office in different parts of Taiwan, we have a special room in the office where the environment is cozy so that children interviewed by the prosecutors will feel less stressed. As for the appraisal or evaluation of the child's state, again, the prosecutor will work with medical professionals. In the unfortunate case where the child is dead, and we also have experts to help us to examine the body of children who are under the age of 6. Thank you. Judicial Yuan. If the child has to appear in the court, we try to protect children by not having them appear in the court as much as we can. If they have to appear in the court, maybe we can have remote interviews. In other words, their best interest is our top concern. So, for example, we have reviewed relevant regulations and provide training for judges and the prosecutors so that they know it's necessary to have children appear in the court. If they have to appear in the court, we will have a separate room to allow them to make statements, serve as witnesses in a safe environment. In addition, there will be a special corridor to help children to enter the court and leave the court. They don't have to confront their other persons or perpetrators. And when the child has to appear in the court, we pay close attention to their mental and physical health. For example, we want them to feel relatively relaxed when they enter the courtroom. Moreover, we also provide them with some picture books so that they can read and they can feel relaxed when they get into the court, facing the pressure of being interviewed. So we are working on strengthening these measures to meet the spirit of CRC. Thank you.
For this explanation. Under Article 25, only two two questions. In the third report, just at the beginning, paragraph 258, you explain that children or citizens of Taiwan are entitled to vote in referendums when they reach 18 years of age, and in elections when they reach 20 years of age. Why do you have this distinction?
The Ministry of the Interior, please. Civil Affairs Department of the MOI. In terms of the electoral right, the 20-year requirement is part of the provisions in the Constitution. The Constitution doesn't provide for the age for referendum participation. That is why we have a separate requirement for 18. As the Constitution provides for 20 years of age to take part in election. In fact, we have a proposal to amend the Constitution, and according to our Presidential and Vice Presidential Recall Act, there's also provisions about the age limit. In fact, starting next year, the age of adulthood in our law will be reduced from 20 to 18. And the Civil Code has made such a change. And in the future, if we can change electoral laws and regulations, I believe we will be able to reduce the age from 20 to 18 for people to take part in elections.
That explains to me, because usually the voting age, whether it's for referendum or elections, is usually the active participation the same. So, and it's also good if you decrease the majority age so that it also conforms to the Convention on the Rights of the Child, which defines children until the age of 18. Under paragraph 262, I read as follows. As of December 2019, there were 59,865 people accommodated in correctional institutions who had the right to vote but were unable to do so. Can you please explain why they were unable to exercise their right to vote?
那个内政部先说明一下。
The MOI, please. Civil Affairs Department speaking again. For the group of people you describe, actually this is in line with the Electoral and Recall Act we have, because you have to go to the polling station where your household registration is. Because they are in the correctional institutions, they cannot go to the polling station. If we want to allow them to vote, that means we need to allow the absentee voting. But in Taiwan, we plan to liberalize absentee voting in referendum cases first. For absentee voting promotion, as I said, we would like to start promoting such liberalization in relation to referendum. The Central Electoral Committee is planning that hopefully in the future, all eligible voters can exercise that right. But the people in correctional institutions are not yet considered as a priority to apply that planned liberalization. Correctional agency speaking. Speaking of the inmates' right to vote, for absentee voting to take place, this, of course, is under the purview of the MOI and the Central Electoral Committee. We need to have legal basis to support that liberalization. Once the legal basis is in place, we will work along with the ministry and the committee. If we want to allow these inmates or people in correctional institutions to vote, we have to first amend President and Vice President Recall Act. We also need to amend. Basically, we do not prohibit inmates from voting.
I think the problem is what MOI mentioned. Some other acts about election, about referendum, are not sure how to overcome the technicality for allowing inmates to vote. For example, what absentee ballot is a way, but if we send all the inmates to vote in a certain place, some people may think that, oh, this is vote rigging, this is election rigging because you send a batch of voters to vote.
25 of the covenant reads very clearly, every citizen shall have the right and the opportunity, without any discrimination, to vote. So these words and opportunity also means that if they have a right, they should also be enabled to exercise their right. And you say explicitly in paragraph 262 that they have the right to vote. So they are not excluded. But you are simply not providing them with the opportunity. So it's a clear violation of Article 25. And there are, various decisions and also judgments of the European Court of Human Rights, which are sometimes also not loved by certain governments like the United Kingdom. But I think, it's clear if you have a right to vote, you should also be able to exercise it. If you look on the voting rights for persons with physical or mental disabilities in paragraph 264, there you see that you do quite a lot to enable persons, for instance, who are in a wheelchair, or there are all kinds of things. You can put polling booths also into prisons. You can do absentee voting. You can do electronic voting or by letter voting or whatever. So it's not difficult. And most countries in the world actually do provide that. I hope that it's not only the people in correctional institutions. What is about pre-trial detainees? They have the presumption of innocence, so they are even stronger. They also should be provided. There's nothing written in your report. But if you say in correctional institutions you cannot provide them with the opportunity to vote, how do you do that in pre-trial detention facilities? Are they also de facto excluded from voting? Or do you provide there the opportunity for them to vote?
As of now, for pre-trial people who are in custody, they are not able to vote. But the government has noticed this issue. MOI and Central Electoral Committee are taking active measures to change this. If they have come up with supplementary measures, then I think pre-trial suspect and inmates will be able to vote. I think we are working with the competent authorities which are in charge of election. Anything else from MOI? I agree with Deputy Minister Chen. Absentee voting will be initiated with the referendum first. Then phase by phase or stage by stage, absentee voting will be expanded to other populations of voters. We will do this gradually.
Thank you. Those were my questions in relation to Article 25. Roka, please.
Hello, can you hear me? Thank you. Thank you again. Oh my gosh, we're nearly the end. I'm still excited. Thank you very much. I would like to raise again the political rights, especially in the participations in the decision-making processes and the elections of public officers and legislators. The concerns of indigenous peoples, there is the report in response to the first, second list of issues by of the third ICCPR and ICESR committee, and this is submitted by Amnesty International, some of the indigenous youth working groups, also some of the organizations. They are saying that the first categorizations of indigenous peoples is really the roots of the main problems they're facing, including the rights to votes, the rights in their political participations. For example, here, because they are divided into mountain and plain indigenous people, so there's one example here, so let me read it. The Tayal peoples, the Paiwan peoples, and the Sai-Siat people, for example, within the same peoples or nations, some of them are classified as mountain indigenous peoples, while some are plain indigenous peoples. In the case of Sai-Siat peoples, half of them are classified as mountain indigenous peoples, and the other half are as plain indigenous peoples. For the Kafalan peoples, part of them are plain, and few of them are mountain. However, there might be some Kafalan being classified as Pingpu in the future. That means there will be the possibility for the members of one people to be classified into three status that will, when they follow the procedures, meaning that they are not able to vote in the respective territories, or they are not, they don't enjoy the rights to be elected or even to vote. So I think these are it's quite complex, the situation that we heard from indigenous peoples, and especially for the Pingpu, because they are not recognized. So definitely, it seems there is no chance for them to, according into the covenant, they have the right to elect their representatives. So I think these are the things that, again, around the situations of the basic recognitions of indigenous peoples on this country that needs to be revisited. And I really wanted to know what is the next step. Because again, we are going to coming back again and again, probably next 5 years, the same thing again. So I think that's from me. Thank you very much.
好，这是内政部中选会还。
MOI or Central Electoral Committee? Who will respond to this question? This is Central Electoral Committee. I'm in the back. Let me explain first. Regarding the electoral districts for indigenous people, well, in our constitution, it stipulates that indigenous legislators are also separated into 3 seats for mountainous, indigenous, and 3 seats for plains, indigenous peoples. We carry out our duties according to law, to constitution, and conduct election accordingly. As you mentioned, maybe we should combine the 2 categories, mountain indigenous and plains indigenous people together. I think it's about whether or not to change the attributes of the indigenous peoples. CIP had a lot of discussions on this. Maybe CIP representative will like to respond to this too. Mr. Chair, dear committee members, I am the director of the Social Welfare Department of CIP. I remember on May 10th, another CIP representative responded to questions on indigenous peoples. Well, dividing mountains and plains indigenous peoples. Well, I am looking at Article 2 of the Indigenous Peoples Identity Act. Well, the distinction came from decades ago, and indigenous people who live in the mountainous area were categorized as mountain indigenous people, and indigenous people who live in the plains were categorized as plains indigenous people. Well, CIP, some NGOs, and MOI have many discussions already, but indeed, it is a very complicated matter. It involves many different pieces of legislation. We will continue the discussions. If there is more information in the future, we will provide you with it. So the question was also about maybe there's one people, for example, Ataya, and some in that population, some of them are seen as mountain indigenous, some are seen as plains indigenous. So how does this classification works? Is it based on where they live, the areas they live? Well, indeed, in laws, it is clear that it depends on the regional area. And so if we are talking about Peinan or Taya peoples, they used to live in the mountainous area, so they are classified as mountain indigenous peoples. So that's how this classification works.
Thank you. Any other questions on Article 25? Then we have still left from the morning the question of facial recognition. Have you been able to collect the information that we requested? Yes, please.
The NIA at the airports, the use of facial recognition. Chair, so this morning we talk about the use of facial recognition system at the airports, right? We have not received the data. Can I provide the information later? Please do it as soon as possible, since tomorrow the committee members are going to write the concluding observations and recommendations. Basically, yes, there are rules and regulations governing the use of facial recognition technology at the airports. In other places, for example, in prisons, we have another law that governs the use of that technology in prisons. In other words, we cannot deploy facial recognition technology wherever we feel like to. There must be laws and regulations that allow and govern the use of that system. How about NDC? In GDPR, how about regulations in this regard? NIA speaking again. In fact, before this session, we already provided the data to the secretariat of the conference organizer. We have already provided the written explanations to the secretariat staff. Or maybe you can give some oral explanation first. NIA, do you have the data at hand? I'm sorry, the data is prepared by a colleague from another department. So I think we should first have a look at the prepared document.
Airports and prisons, where else is facial recognition technology used?
Any agency representatives that can share some information? The National Police Agency said they don't use it. Could you make copies so that the reviewers can have the information we have prepared? How about the Criminal Investigation Office Bureau? The CIB, Criminal Investigation Bureau, does not apply or deploy this technology.
On this topic,
we are going, well, Deputy Minister Chen, the Judicial Yuan would like to provide additional information. I would like to ask Judge Lee to explain. Yes, at lunch break, we went back to the office and reviewed the database in terms of the use of facial recognition technology and big data analysis. The administrative court judgments have not made any reference to the use of facial recognition technology in their judgments. There's no such reference in the judgments.
for this information in writing.
They say it's the place on physically isolated intranet. Are these both the how is it? The you mean the during only the data during the immigration inspections, or all the including also the data of just general public, of general citizens of this country? Because immigrations is where you know, it's very specific here that they use the isolated intranet, meanings it is really isolated. There is no internet connection. There is no way people will steal it through the backbone of the internet, which is safe. When somebody is stealing it, meaning somebody inside is taking out that data. That's the only way. So I think that's more or less secure, protected. But how about the other data of the citizens of this country? I think that's very interesting.
国发会，你们有没有资料可以说明一下吗？国发会。
National Development Council, please. National Development Council is in charge of protecting personal data. Basically, as far as I know, in terms of the use of facial recognition technology, unlike China, we do not use it on a great scale. That is why there are a few institutions or agencies that would set up such a system. For example, CIB, Criminal Investigation Bureau, does not have such a system. We know that in some places, some countries, big gyms would set up such cameras to have people's face recognized, but that's not the case in Taiwan. It's not like the head of any agency can decide to set up a system. And yes, that's correct. Right now, it's isolated, unconnected to the internet when the technology is used. And it's not connected to the internet. Of course, we know the hacking risk is always present, but at least it's isolated.
Any other open questions that were left? Any news about the moratorium? Perhaps that we can use in our concluding observations?
Here, I think one reviewer asked about protection of children. For example, whether we have a commissioner for child protection. In response to that question, we don't have a so-called ombudsman system for children's protection because we have a so-called reporting system. Teachers, police officers, doctors, social workers, and people in their capacity would detect signs that children are being abused. They are tasked to report to the authorities. In other words, I think they also play the role of ombudsman of some kind to protect children. So we don't have a children's protection ombudsman system. We don't have that.
All right. Then I think this concludes our very, very enlightening discussions that we have had with you, Deputy Minister Chen, and all the other representatives of the different governmental agencies and ministries of Taiwan. We will have still the last meeting with non-governmental organizations in about 10 minutes on the cluster 5. And then we will tomorrow sit together in closed meetings where we are then drafting our concluding observations. If there are any news that you feel are important, that we include them in the concluding observations, including, of course, a possible moratorium on the death penalty. If that should be still available, then please make it available to us until tomorrow so that we can include it into our concluding observations, which will then be presented on Friday at 3 o'clock to the government. Thank you very much for your presence, and I know it's a little bit tiring to go through so many different questions, but I'm extremely grateful for all the cooperation I have received, we have received from so many different agencies, including the judicial one and all the other agencies. Thank you so much. And a particular thanks also to our interpreters, all of them, including the sign language interpreters. That was a great help. Thank you. Yes.
非常谢谢各位长官贵宾的与会。
Thank you very much for your participation. We will proceed to the meeting with NGOs, Cluster 5. It will commence at 20 after 5.
人权
Thank you.
是台湾最美丽的风景。
有需求者请改至11楼使用，谢谢。
台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。 台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。
We're about to begin Cluster 5. Please be seated and switch your cell phone to the vibration mode. Thank you.
两公约第3次国家报告国际审查会议
Cluster 5, meeting with NGO. The review scope includes Article 18 to 25 and points 73 to 77 in the COR. Please raise your hand so that the reviewers can see where you are. And while you speak, first introduce yourself, your affiliation, your name. When you speak, please make sure you speak at a reasonable rate so that interpretation can be performed. Thank you. Chair.
Thank you very much, and welcome again for the last round of our deliberations. And I will go again article by article. So we started with freedom of religion, conscience and religion in Article 18. ROC, do you have specific questions to the NGO community, or shall we ask them first to provide us additional information? No, freedom of religion.
Freedom of religion. Well, there's nothing much from the government, and also nothing much also from so far that we have received. So if there's any burning issue that we really need to put on the recommendation, I think it's time to hear, I think, from our friends here.
Yes. Okay, anything on freedom of religion that you would like to add? Please, 1, 2, 3. Please, you have the floor.
大家好. Good afternoon. I speak for the Taiwan Parents Protect Women and Children Association. Per Article 18, I think Taiwan government should fulfill the spirit of the covenant by realizing human rights protection. We want to have our children receive education that is in line with our belief, our religious belief, but that is not the situation right now. And Right now, there's a draft amendment to the guidelines for parents' participation in school affairs during compulsory education. It seems that there are many restrictions that are binding imposed upon parents. We disagree and disapprove. Our parents' right to education, to educate our children, must be respected. Thank you.
Please.
Good afternoon. I am Lin, speaking on behalf of Tax and Legal Reform League. Since the lift of the martial law, I think there is a very serious suppression of religious freedom in Taiwan. Over 10,000 people suffered as a result. Yesterday, you said that Taiji-Men case is a tax victim case. It is not covered by the ICCPR. We were kind of disappointed because the Taiji-Men case is definitely a case of religious suppression and oppression. In that case, European Times, a publication in Europe, has discussions with scholars and experts in Europe about the suppression experienced by Taiji-Men. And here you can see these are two books. The two books, the Winter magazine actually has collected comments from over 100 international experts. Again, the expert says that this is not a tax case because Taiji-Men master disciples are not guilty. However, their land is grabbed by the government and they are discriminated against by government agency. Let me explain what has happened. When Taiwan first lifted the martial law, at that time, the authorities had a crackdown on certain religious groups. Some of members of the religious community fled Taiwan. Taiji-Men organization and its followers were prosecuted. Many of them were discriminated against because they had been smeared by the prosecutor in charge of the matter. Followers of Taiji-Men lost their job. Many of them were unable to attend school.
Yesterday, some committee members said you know this case very well, but we think there is a new piece of evidence which is very important. It's a new fact maybe you are not aware of. After the second review in 2017, after you leave in 2018, there was a very important new piece of evidence. That is the judgment 442 from the Supreme Court. I think we attach this judgment to the submission that we just delivered. The administrative court acknowledges that Taiji-Men is a religious group that practices Qigong, and which is to say that they acknowledge that this is not a tax case, this is religious suppression, and the government using a tax as a weapon. But then they rectify their cases, they reduce the tax monetary amount to zero. And I think we're talking about this case because I want to point out that the Taiwanese government still uses authoritative measures to crack down certain religious groups. These gravely infringe upon the two covenants, infringe upon the right to free religions of the people in Taiwan. And we have been very specific in raising our recommendations to your COR. First of all, well, we mentioned that first point is that Taiwanese government used text as a weapon to attack religious groups and infringe upon their rights. And therefore, this is not a tax case. And the two covenants should protect people from being abused by Ministry of Finance and from the fact that the administrative courts are not able to protect people, and that administrative enforcement agency taking the assets away from the people. I don't know if you think this can be considered as a case that should be protected by the two covenants. And this case.
Give the floor now to the next.
好，谢谢。
Please.
好，我想要建议这个国家报告的表。
Please refer to Table 19 of the state reports. It lists many TV stations and media channels, but it doesn't list some TV stations that have been shut down by the states. It seems that in Taiwan, only the media that support the government can survive, and no media can criticize the government. I think CTI is one of the TV stations that criticizes government policies, and its renewal for license was denied. So I think the list should be adjusted to include those channels which have been shut down by the government and the reasons as well.
It's already on Article 19, so we are now on freedom of expression and the media. Please.
This is Taiwan Association of Gender Sexuality Rights Protection, and I want to speak in response to Article 23.
We are now on Article 19 and 20. Freedom of speech and freedom of the media. Bill, do you have any particular questions to the NGO community?
I had mentioned when I addressed this issue of Article 19 earlier today about the fact that several of the provisions in the criminal law, which are listed in the report by Taiwan, appear to encroach upon or have the potential to encroach upon freedom of expression. But that aside from the provision dealing with public insult, which was addressed in the opinion of the National Human Rights Commission, we didn't have information to suggest that the other provisions dealing with things like obscenity and so on had been the subject of abuse, and the government didn't volunteer any information to suggest that. So the question is, do representatives of civil society, non-governmental organizations have elements that would suggest that those provisions have actually been applied in an abusive manner that unduly restricts freedom of expression?
Any information on this? Yes, please.
我以为这样声音好，不好意思。
Hi, I'm Wang Xi from Taiwan Association for Human Rights. Regarding criminal code in Taiwan, there is a defamation or insulting public agencies. I think public insults may be problematic because in Article 153 there is offense of incitation. And there's also an insulting public servants offense in another article in criminal code. And some of the provisions are removed, which is a good thing, but some have been aggravated. And after the Sunflower movement, some people are persecuted according to Article 153, and we think this should be removed because these may affect or this may impose limitations on the freedom of speech of people.
Please.
In addition to criminal code, I also want to speak about misinformation. In the government session, I think some prosecution cases were mentioned. Now, the element in some provisions regulating misinformation are not very clear. Many of those cases were not prosecuted. I think it shows that maybe laws and regulations are not very clear as to what is misinformation. I also want to add freedom of expression. I think this is another aspect of religious freedom. Because to express our thoughts, we can use our speech, we can use our religion. In the past, religious rituals include burning incense or burning paper money as a ceremony. But in recent years, the governments almost threatened temples to reduce the practices of burning incense. This is intervention of religious rituals. I think human rights regulations should be based on legal regulations, but currently administrative procedures are used to take away of religious freedom of people in Taiwan. The land of the temples has been taken away in the past. People can build temples in the mountains. But now, with the National Land Act, the right to build church or temples in the mountains has been taken away. And the rights before was taken away. So administrative measures, administrative orders are used to limit, to remove our right to religious practices and religious activities. When it comes to religious education, church may provide such a textbook on Christianity. But in Taiwan, some outsiders, non-religious people, write textbook about Buddhism or Taoism, and they even inserted some mere campaign against some of those religions. So we hope that the Taiwanese government can refer to international practice and treat all the religions in a friendly manner. State and religion should work together. They are not enemies. We hope that in the future, in managing religious groups, there should be a law that is passed by the legislative yuan, because currently administrative measures are leveraged to manage religious groups. Some tax rules are used to manage the finance of religious groups.
Okay, thank you.
Not to be too long, please.
好，是台湾全国妈妈互加会。
This is Taiwan Mothers Shield Alliance. I want to speak about misinformation. I think sometimes people feel that the government provides misinformation, especially on information regarding pandemic. The government keeps talking about the bright sides of the vaccines. They seldom talk about the side effects of vaccines. And on government websites, there are sections that clarify false information. And when parents point out something that is wrong in the textbook, there is a clarification by the government, by the Ministry of Education on their website, but their correction is wrong and therefore is misinformation.
喂，不好意思，那
I want to add something. Well, following what Amnesty International said, many cases were prosecuted by the Social Order Maintenance and Act. It's an administrative act, so all the process under that act is very quick, and some of the discretion is taken by the police officers. The summary judgment is given in courts. In many of these cases, since the proceedings go too fast, so the punishments may come too fast without clarifying the fact too. There were cases about delivering information about disasters and so on, and social maintenance order was used again. And there should be some laws and regulations to regulate the speech, make sure that there's no misinformation. But we think that these kind of provisions should be clear. If the government say that, oh, information is evil and false and malicious, then this is information. Then this is misinformation. But we think that the definition of misinformation should be clearer in order not to punish the wrong people. And the information regarding LGBTIQ also exists. And maybe later on when we talk about anti-discrimination, we can come back to this. Thank you.
Now we come to 21 and 22. Perhaps do you have first questions to the?
Yeah.
Yes, because
21.
We would prefer actually to have a conversation rather than people reading out statements that you can also hand to us. So as we did it the last times, that it should follow up to what we were discussing with the government, and questions that we raised with the government which were not really answered, whether you could provide us there your views and answers, please.
Yes, thank you. Concerning the Assembly and Parade Act, we are informed about the draft which has been pending since 2016, but not yet adopted, despite our recommendations. We know that also that two important issues should be solved, will be solved if the draft is adopted, concerning the abandon of penalty and replace the permit system with a reporting system. And that, as far as I understand, in fact, this has already happened, even if the draft is not yet finished. But I would like to know whether there are other important issues which are not solved and will not be solved even if the draft is adopted.
Mm-hmm. Any explanation, please?
National Amnesty International, Article 21, the right of assembly. I would like to talk about the use of non-lethal weapons. For example, water cannon, tear gas, taser, they are not lethal weapons, but if inadequately applied or within a closed environment, there still can be serious harm to human health. For example, in Korea, one elder man died because of the impact from water cannon. So I think there should be more clear guidelines and regulations. Not to mention the draft amendment has not been adopted. So many civil associations would like to have big gatherings. Even now, under the pandemic, they can have online meetings, but for those civil societies to organize their representatives, sometimes they still have to get together. In that case, their right to assembly should be protected.
这个
我这边是代表中正。
I speak on behalf of the Research Center for Department of Financial and Economic Law, National Zhongzheng University, on the Assembly and Parade Act. I think the government provided wrong information. I would like to share with you some data. That act, in 2020, there was a proposed amendment, but only one provision was amended. So the government said they would like to amend this and that, but none of that materialized. So I think they delayed the amendment on purpose. In addition, the Judicial Yuan interpretation already set some restrictions on the parade and the rallies are unconstitutional. However, the government representative said since the parade, the Assembly of the Parade Act is still in force, therefore they still have to act in accordance with it. However, in 2020, between July and September in 2020, there's one civil group applying to have a rally for 15 tons. They were rejected. This is a gross violation of human rights in Taiwan. In 2020, in the state report, it said that the rejection rate of rally application, actually there were only 35 cases that were rejected. But as I said, within 3 months in 2020, 15 rejections happened. Also, in elderly volunteer, a woman volunteer held a placard in protest, and she was arrested by local police officer. She was interrogated for 6 hours in late hours, and she was then transferred to the local district prosecutor's office. And there's also restriction imposed on her residence. She eventually passed out, and she was diagnosed of suffering PTSD in the hospital. Yesterday morning, in the lobby of this building, some civil groups protested in the lobby, but they were dispersed, expelled by police officers. So, you see, we tried to apply for a permit to have a rally, but we were rejected when we filed such applications. When we tried to protest in the lobby, the police officer drove us away. So what kind of freedom of expression do we have? There are so many protests in the past couple of years. We can find no relief or remedy from whatever government agencies, not to mention the authorities, kept smearing us. The police that arrested the woman volunteer also disseminated misinformation about that woman volunteer, accusing her of being violent. So I hope you can include in your concluding observations, urging government to make changes.
Per, do you want first to? Yes, is it?
I want to confirm first that can we talk about the Article 22 at this part?
Yes.
Okay, thank you. 好，不好意思，那我用中文。
Okay, thank you. Assembly and the parade. As government replied, after 2016, because there's disagreement, the proposed amendment was not adopted. However, in the process, the National Police Agency and the National Security Council's attitude is quite critical. they agreed to remove the criminal punishment in the Assembly and Parade Act, but for other amendments, they disapprove. For example, the compulsory dispersal of the protesters by the police officers, they want to retain that. The NPA lacked the willingness to make amendments. That is why there's no progress on the amendment. As for urgent rallies and spontaneous rallies, in fact, the NPA released guidelines handling such rallies after the Judicial Yuan interpretation was released. However, not much difference has made. I have to say there's a gap between the performance of police officers in the country, in the countryside and in the city, because in the city, the police officers have a better idea. However, they still don't abide by the covenants strictly, not to mention police officers in the countryside. As for the right of assembly, the right of association, financial groups, social groups, civil groups, there are so many different regulations governing different civil groups. I think for the Civil Groups Registration Act, since its inception, there has been no amendment. In 2016, there were proposals, but there's no progress made whatsoever. The problem is, since there's so much red tape involved, even though people can still apply to establish civil groups, but the red tape can be very prohibitive. That is why it's a form of restriction too. For foreign NGOs to set up a civil group in Taiwan, there are no relevant regulations. It's even more difficult. As for unions, I don't think we see any representatives from unions, so I'll just share my experience. Right now, Taiwan is very unfriendly to union formation and strikers. Usually, workers will have to organize their own groups in the form of NGOs. For example, we do see a lot of examples of union busting in the service sector. Sometimes the workers may protest on the street, but still they would be forcibly dispersed by the police.
Really to be, and trade unions are also dealt with more in the
好，那就先这样子好了，剩下的再发言单，不好意思。
Yeah, thank you. Then we come to Article 23. Shanti, do you have any specific questions to the NGO community? Yes, that's what you raised, but it's in general about family and... No, I mean, if you don't have, we can just hear the NGOs and then...
let's hear them.
Yes.
They have to say.
Please.
Okay. And this is Taiwan Association of Gender Sexuality Rights Protection speaking. And I want to raise an issue about the rise of social egg freezing may mislead people to delay their starting a family, cause harm of the health of women and future offspring. In response to the problem of low birth rates, our government provides subsidies for infertile partners to use assisted reproductive technology. But what was crazy is that almost every week in Taiwan, celebrities and internet celebrities share their experiences about egg freezing or ART publicly, which makes people feel that this is a novel and popular option that is worth emulating. So young unmarried women go egg freezing now in order to have children of their own in the future. The truth is that that procedure for egg retrieval may have the risk of infection, ovarian hyperstimulation syndrome, and increased risk of ovarian cancer in the future. And compared with natural conceived children, the offspring born after assisted reproductive technology have more chance to get autism, mental retardation, cancer, and other abnormalities after birth is triple. Besides, there is not enough data to indicate how long eggs can stay in liquid nitrogen and remain viable. Dr. Callan, she is a Yale Medicine reproductive endocrinologist and infertility specialist, says, I don't want people to think of it as something they can do to delay starting a family more than they otherwise would. You are not guaranteed that you will be able to use those eggs when you freeze them. So our suggestion is incomplete information is false advertising. So the government should supervise and regulate artificial reproduction operators to inform their customers with complete information. Second, the government should provide complete and easy accessible information to public. Third, government should provide information about natural reproductive technologies. It's much cheaper, such as natural family planning method or fertility awareness-based method can be used to increase conception rates. Thank you.
Thank you. Anything else on 23, please?
是委员好，我是。
Hi, I am Jian Zhijie from Taiwan Alliance to Promote Civil Partnership Rights. In the state report, the government has stated that in order to resolve transnational same-sex couples issue, they want to revise different laws like civil law for foreign matters or the regulation that govern the relations between people in Taiwan and mainland China. But these two amendments have not yet been submitted to the legislative yuan. The executive branch has not given a schedule as to when they are going to deal the issue of transnational same-sex couples and their right to register in Taiwan. That's the first fact clarification. The second is that the government refused registration of same-sex couples involving a foreign spouse because of the limitation of civil law for foreign matters. However, last year we represented 3 couples, and in three cases, High Court of Administrative Court judged or found that denial of such transnational marriage registration was illegal. But even with that, the government has not changed its practice, and therefore transnational same-sex marriage couples could only obtain their right to marriage through litigation, because with the court cases, only those who win the cases can register in Taiwan, but that right does not automatically be executed for other transnational couples. And third, there is a strict control during pandemic, and it doesn't even consider the right to reunion. And some transnational marriage couples, some of them have to leave Taiwan because this is a foreigner. and some of them cannot wait, so they go over surgeries and change their sex. And by altering their sex, they can more easily register their marriage in Taiwan. So the government has delayed 3 years as to the issue of allowing transnational same-sex marriage. We think the government should give a very clear schedule. And before the legislation is amended, the government needs to ensure the right to reunion. At least the spouse should be given the status of the spouse so that they have the legal ground to stay in Taiwan and have the right to reunion.
Please.
委员好，台湾同志。
Hi, I'm Reese from Taiwan Tongzi Hotline Association. I want to talk about Article 23 of ICCPR. And Article 10 of the ICCPR also stipulated the value of the family. It says that the family is a natural basic group unit of society, and the state should try its best to provide protection and assistance. And Act for implementation. If
you read out, if you have it in writing, then give it to us. But if you need to read, then please slow down.
OK, sorry. 好，针对同婚专法对于
Well, the Act for Implementation of JY Interpretation Number 748 didn't give full protection to same-sex couples as heterosexual couples. For example, in Taiwan, any single person can apply to adopt a child, and any married heterosexual couples can apply together. But for a married same-sex couple, the only option for them is to divorce first. And after the divorce, one of the couple adopts as a single person. Even with the successful adoption, they can get married again. But current law does not allow the partner to adopt and be registered as a parent, so leaving them without equal rights. So only one parent has the right as parents, and they need to engage in legal proceedings to obtain parental right. So we hope that the Act for Interpretation of JY 748 can be amended so that LGBTIQ families can have the right to adoption.
We have discussed it already and raised it also with the government. Yes.
I want to ask a question.
Yeah.
I don't know how many of you were here earlier when we were talking to the government, because in relation to same-sex marriage and the fact that if one member of the couple is a foreigner in whose country same-sex marriage is not recognized, they cannot register it here. We raised the question, and I think somebody from the Ministry of Justice said that they are changing that law. In fact, they said, if I'm not mistaken, they said tomorrow the legislature is looking at it or something like that. I thought I heard that.
Yeah, but I said
Are you telling us that that is not true? Is it not true?
No.
It's not true.
这个是误会。
This is a misunderstanding because tomorrow the discussions will be on adoption. Adoption for transnational same-sex couples. It's not about registering marriage in Taiwan. So clauses related to transnational same-sex marriage has not been submitted to legislative yuan at all.
In Taiwan, and we didn't discuss this with the government though, is there any instance of forced marriage where someone, a young person, is by the parents or guardians or whoever, is forcing them to marry somebody that they do not want to marry? Is there a problem of forced marriage? Is there? Yes? No. Okay. Fine.
Thank you. Please.
我是台湾全国妈妈护家会联盟第2次发言，我也是想要针对 第23条。
This is Taiwan Mothers Child Alliance. This is the second time I'm speaking. I want to talk about Article 23 as well. Because for a person from death to from birth to death, I think this person stays in the family. And in the morning, the government talk about low birth rates in Taiwan. I don't know whether you have noticed that the family policies in Taiwan are very fragmented. So there is a subsidy for artificial impregnation and so on. But the policies are also scattered around. There isn't comprehensive design, meaning that family policies are in the hands of so many different government agencies. I think this is a big problem. So I recommend that the government should create a higher level executive agency as the coordinator to coordinate all the family resources and to come up with comprehensive national family policy.
That also leads us, I think, to Article 24, the rights of children, please.
Thank you. I am Lin Ziwei, Taiwan Alliance to End the Death Penalty. I have some recommendations under Article 24. Government representatives and state reports have not mentioned this. That is how death penalty affect family members, especially the minors in the family. In Taiwan, Sun Wenbing was given a death penalty, and in 2-3 years ago, another gentleman who was executed had children who were minor in their family, but the judge believed that a death penalty, in fact, meets the best interest of the child in the families, or it even meets the requirements in ICCPR and NCRC. In the society in Taiwan, some people use the vocabulary in human rights field, but to say whatever they want to say. It happens in the government, it happens in the private sector. I believe that the community members have already noticed that, but I think the government needs to be especially careful. I want to point out that for the invisible victim, meaning the children of death row inmates, there is no legal protection. Where are they? How many are there? We don't know, because these children are not even seen. I think this is a big issue. They are victims, and they are invisible victims. There is little research on this regard, but according to our experience at our alliance, the family members and the children of the death row inmates are stigmatized. They dare not come out to the society, and there is no assistance from the government to them. So we recommend the government that the government need to review the administration, the judicial and enforcement aspect revolving around a death penalty case, and all of the measures have to meet the best interest of the child. Other than that, the government needs to provide psychological support to these children. I would like to wrap up here. Thank you.
There is a lot of research ongoing on the rights of children in relation to the death penalty and imprisonment also as well. But it is, thank you very much, it is an issue that has been neglected very much in the past, yeah, the best interests of the child. We were also discussing about, and that's a question that I have, is there a deinstitutionalization policy currently carried out by the government of Taiwan?
I'm sorry, what was that again?
Whether there is a deinstitutionalization policy, so a policy that is aimed at getting children out of large institutions in order to bring them into smaller family-type settings, such as, of course, foster families, but also other small groups. Are you aware of any policies in this direction? Please.
But, in the concluding observations of the CRC review, there is a recommendation to deinstitutionalize. And what the government does is to not encourage large institutions, but there are still small-scale institutions, because the families that are willing to adopt children are not too many.
Yeah. Mm-hmm. Please.
I know some county and city governments have plans to create a home-based or home-like shelter. So children go to a organization which is family-like. There are caretakers, and children are at the center of the program, and they can be taken care of in that environment.
Yes.
In terms of family education, I have to point out that the budget this country assigns for education is too low. In 2019, there's an increase from 210 billion NT to 300 billion NT. That means for each citizen, only 13 NT is spent on education. We know that education is important, but the government sets aside so little budget. As a result, parents have a difficult time educating their children. But schools do not welcome parents' participation in their in the program. In fact, some parents of certain religious backgrounds have suffered as a result because gender equality education is contrary to my religious belief. As a result, I have to have my child homeschooled. I know that Taiwan seems to boast diversity. We are also the first country in Asia to legalize same-sex marriage. However, in practice, other voices have been silenced. So it seems that the government is trying to prove that we are progressive, we are very advanced, but parents like me have been discriminated against. Thank you.
If I don't see anything on Article 24, then Article 25, the right to vote and other forms of political participation, please.
Yeah, I am Song Li Huang. I'm with the Covenants Watch. 刚刚在审查的时候有提到监狱。
It was discussed that the inmates are unable to cast ballots, but according to Taiwan's electoral regulations, I think there is a need to amend the existing electoral regulations, because without the absentee ballot system, we have to go back to our hometown where our household registration is. In that case, young college students or workers working in towns and cities outside their hometown will have to take a day off and return home to cast ballot. This actually can deprive young people of their right to vote. The second issue is on mountain indigenous people and plain indigenous people according to the relevant electoral regulations are covered in the amendments to the Constitution. So it's difficult to change because there's such a high threshold to amend the Constitution. So the government basically forces indigenous people to classify and register themselves as mountain or plain people. I think this is the first issue that has to be addressed. Another problem is if we want to run for mayors or city councilors, we have to first pay up a huge sum of money as deposit. If I do not receive, say, 1/10 of the votes that are equivalent to the 1/10 of the eligible voters in my district, I would lose the deposit. This is definitely a financial burden on young people who are aspiring to run for public office. So that's something has to be changed.
Go back. What would be Governance Watch recommendation for the right to vote and participate for indigenous peoples? What would be the best solution?
Because it's in the Constitution, so it is difficult to change.
But let's say even if you change the Constitution, what should be changed?
Well, there is a proposal from the indigenous groups that perhaps they can have two ballots, one for a indigenous representation, but another one for their local representation. So it will be a dual voting system for them. That is one proposal that was raised.
And for the elections at the national level, is there anything that needs to be changed? Or presidential elections?
They don't have a restriction on voting in terms of presidential election, except that they need to go back. And if you travel from Taipei to Taitung, it's going to take a lot of money and time. So that would be a burden for them.
So it would be again absentee voting.
Or another registration specifically for voting. I mean, you can register a different site or location to vote. That would be possible too.
Mm-hmm. Thank you. Any other? Voting by letter, for instance. That doesn't exist at all. No. So you always have to go to the poll where you are registered. Yes. So you can't get permission to vote somewhere else. No. And if you are outside the country, you cannot vote at all. Yeah. Because there are hundreds of different ideas how one can cast one's vote in so many systems. You can, whatever. So that all doesn't exist. So the only way is you have to go to your poll in your, where you are registered.
Yeah, the household registration.
The household registration, yeah.
I agree, because in this statement, again, they emphasize on the classification in the Constitution is the main problem to everything. That's what they say, basically. So there is, like constitutions, and then if there's any, and then go down to indigenous people's basic law, and then the Pingpu is the one who's the most lacking behind, so it's like ladders of injustice. So I think it's maybe we need to think about that later.
Mm-hmm.
but I just remember on the rights of the child to be protected. There is one we actually asked from the previous recommendations, but it's under the debt, how do you call it, the debt bills regulations or something, that the name of the children should not be announced, should be covered. I think there's one in, I cannot find it just now. So, but I think we can go back and look into that, the protection of child under that privacy as well. Yeah.
Yeah. All right. I think we are also already at the end of our time. Any other issues in relation to what we were discussing today, 18 to 25? On which article is that?
May I, because I just heard that a committee asking the question about face recognition.
Facial recognition, yes.
May I?
Yes.
Okay. 那不好意思，我要
So, government, in response, Deputy Minister Chen said, as if there's no legal basis for the use of facial recognition technology, it cannot be used. But sometimes we do have the administrative rules to serve as the legal basis. But let me give you one example. Some universities begin to use facial recognition to monitor their students attending classes. But the Ministry of Education only provides guidelines on the use of facial recognition. And the definition of facial recognition in that guidelines is very narrowly defined. So it's difficult to expect that the universities will not abuse such technology. The Taiwan Railway Corporation is also using facial recognition system. In fact, before 2020, at least 80 government procurement projects involved the purchase of facial recognition systems, but we don't know how such technology is deployed and used by different government agencies.
In relation to universities, you say it's not for entering the university, but it is in the classroom.
Yes, they use in the class and to they claim that they want to find out if the student is cheating, or so they will watching about the way of how their eyes moving, or do they sleeping on the classes. This the example just happened in several different universities. But yeah, because they've been criticized, so they close it temporarily. We don't know if they were.
I think that's different. The movement identification is different than what we mean about the face identifications. Because the face
but there's also
it's like your passport, but it is in the digital. So they have your passport and you show up in the airport or somewhere, they see your face and say, okay, your data is here. But I think that's different use. This one that she's talking is I use that for my dog.
Yes, I can understand it, but because we don't have any promise from this school that they will not use it to the recognition.
I didn't know that they use that for the student. They really don't trust you guys then. Yeah. Yeah, but no, because I think I thought first it is to be used to see your attendance, that you are present in the class, but apparently for beyond that attendance list. Okay.
So there's constant monitoring.
Yeah. Yes.
Constant monitoring during class.
Some example also, we also heard about some example, but not mainly. Also, some school want you to use the face recognition during the entry in the period of the COVID-19. We also heard some cases, but not many, because the biggest one will be the example I just mentioned.
And what's about public transport?
We know about a national immigration agency using this kind of the system, but we don't know because Mr. Chen claimed that they didn't get the data onto the internet, but we don't know about how do they use the data, or do they connect it with the database in the government? We're not sure about that. So that's also the question, and we think we will need the government to explain it more clearly. Yeah.
Can I add on the public transportation?
Yes.
在之前在台中的丰原火车站
In Taichung City, in the train station, in some MRT station, we do see the use of facial recognition technology. We don't know if it is still in use or it's been temporarily suspended. Also, police officers also use a facial recognition unit to identify who the one person is. And the National Police Agency just announced that it's not using it anymore. So I would like to recommend something to be included in the concluding observation. And we just said that our government has very little awareness of human rights protection. The government uses their power to tax, to suppress people, depriving people of their rights. So the civil courts and administrative courts, in handling appeals in cases of injustice, would impose a 5-year limit. As a result, many people who have been wronged in the judicial system could not find remedy. I hope the Transitional Justice Committee members can speak on behalf of those people. Moreover, we know that internationally, the very high-profile case, Taijimen, this is a case of religious suppression. We hope that government agencies can be punished and held accountable so that the Article 18, people's right to exercise religious belief, can be protected. Their reputation should be reinstated, and the land grabbed by the government should be returned.
好，谢谢，谢谢。
Please don't repeat all the time.
对，我们会提到这个案子，是因为他
The reason why
觉得，
And it's it has nothing to do with facial. We were now discussing facial recognition.
好，谢谢。
Has nothing to do with this. I'm really sorry. Yes, please. Doesn't work anymore. I think the others have their micros on.
Thank you.
I think your neighbor as well. If you can turn off your microphone. Yes.
Right, thank you. I wish to talk about Article 25A, to take part in the conduct of public affairs.
Yeah.
I hope I don't repeat myself too much, but in order to have an effective participation in public affairs, we need the government to disclose its policy in an early stage to ensure transparency and then a proper consultation process. But the government has been reluctant in opening up for consultation. I think they think that it is inefficient to have consultation. And when they do, they usually ask scholars and experts to come rather than NGOs and stakeholders. So we would like the committee to reiterate the point that has been raised in 2013 and again in 2017 to ensure transparency and participation. Thank you.
Okay, thank you. I think that brings us to the, I saw you, but is it again the same issue or is it a different issue? Is it on Article 25 now? On
我要提的是26条。
I want to talk about Article 26. May I?
6 was
Article 26.
discussed on the first as a cluster 2. So we have done that already at the beginning when we did also dealing with Article 2 and 3, so the all right to equality and non-discrimination. Now we are finishing off with the last articles. Sorry for that. Okay, then thank you very much. Again, my sincere apologies to the interpreters that we are running 10 minutes over time. Also often people were speaking quite quickly, so that was not so easy for the interpreters. Thank you very much. Thank you all for having spent so much time with us, both listening to our dialogue with the government, but also then providing us with additional information on so many different issues. I'm particularly grateful to civil society in Taiwan for your assistance to us. We will tomorrow try to come up with a useful list of concluding observations and recommendations to the government of Taiwan, and we will certainly use many of the proposals and suggestions that were made by you in our concluding observations. Thank you very much and have a nice evening. Thank you.
谢谢各位与会贵宾的参与。两公约第
Thank you all very much. This is the end of the review meeting of the third report under ICCPR and ICESCR.
台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。